Anything on those facts?
Nothing on the facts, Your Honor.
Mr. Richardson, did you hear the statement that she read? You admit and acknowledge that what she said is true? And again, you understand all the rights you're giving up by entering a plea of guilty, those rights we discussed? What is your plea? The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we discussed. The court will accept your plea of guilty, and based upon the statement of facts and your plea, the court will make a finding of guilty. I'm going to order a pre-sentence investigation, Mr. Richardson. I know some about you, but not enough to sentence you, so I'm going to order that, and we'll come back in a few weeks and do sentencing at that time. Anything else?
Your Honor, I know that there have been some communication between the VA and the court and myself about a potential placement for Mr. Richardson. If that is found to be, something that he is eligible for, would the court consider modifying his bond at that time?
Ms. Nicholson, you wish to be heard?
Your Honor, if there's, I know that the idea is to eventually place Mr. Richardson in the Veterans Court. If there is an appropriate kind of secure placement that Mr. Richardson is willing to comply with, I think we would defer to kind of probation and the court's thought on that. I know he left a treatment program previously, which is obviously concerning. But if there's a suitable option that is going to ensure that he complies, then I think we would defer at that time. Maybe suggest a monitor if he were to be placed in a program.
Okay. Officer Vretos, I know that you'll be supervising him even in Veterans Court.
Correct, Your Honor.
Okay, so why don't we look at, I know I'm looking at Bethany's email from yesterday morning and the options that she has. You know who Bethany is, right?
Yes, sir.
All right, so let's look into that. We will, once we get something set up. And I'm not sure, she has different options in there. I guess I would prefer, you were at the VA. Were you in the Dayton or Cincinnati VA?
I was at the Fort Thomas VA. I graduated.
The
and I went
Dom.
to Dayton for one day because I graduated from the SAR program and I traveled to Dayton and I had to pick my daughter up, so I left because they weren't going to let me do that.
Your Honor, I think it was the SARP to the Dayton Dom.
Yes, sir.
The Dayton Dom.
I did
And that's
graduate
when he
one
left.
program, and the day that I left, I did continue with the other program. So I never really even started the Dayton Dom.
She says, so you completed the SARP?
I
Yes, Your
graduated SAR, yes, sir.
Because Bethany still seems to be talking about the SARP program into the DOM.
Yes, Your Honor. I'm wondering if what Bethany's referring to is if he were to re-enroll in the SART due to the relapse that was in between.
Oh, I see.
I can, after this hearing, I can go back and call Bethany and see what
All
she
right.
thinks would be best fit.
That's my interpretation of it too.
Okay.
If
All right.
he is released, would you like the GPS monitor?
Yeah, I think so. I think just to be safe, again, it gives me some peace of mind too, Mr. Richardson, gives you some accountability. So, yeah, let's do that.
Okay.
Let's order an EM. And then in whatever Bethany's recommending for placement right now, I'll approve with an OR bond.
Okay.
All right. Anything else?
No, Your Honor.
All right. Mr. Richardson, I know you had a relapse. I'm not sure exactly what happened there other than you had that, but you sat through some of my Veterans Court before, so I think you understand. I mean, need you to be, got to try to hold you accountable now, okay? All right, we'll get you through this.
Okay.
All right, we'll see you. And you will be required to appear at Veterans Court on the 14th. Is that right? Is
Yes,
that the
Your Honor.
date?
Yeah.
January 14th.
So January 14th is the next Veterans Court docket. I'm going to have you come and sit in on it, okay?
Perfect. So
Okay, all right, see you then.
All right. Good luck to you.
So we're up.
Yes.
I just went ahead and just put remain for now, so.
Okay, I can do it.
do an updated one whenever you.
Absolutely, yeah. I can get that taken care of. Judge
All right, this is case number 23CR40136, the State of Ohio versus Grant Carmack. Mr. Carmack is here on his motion to seal his record. There was a report of probation that was prepared. As everyone had an opportunity to review that.
Yeah, sure.
Anything, Ms. Nicholson, on behalf of the state?
No, Your Honor. The victim did not wish to have any input.
Mr. Carmack, anything else?
No, sir.
Now, I know that you had filed a request to expunge this, but my understanding of the law, I know you completed ILC, but I think that the expungement still is required. A longer waiting period is required for the expungement. But you are eligible to have this sealed, and the court has prepared a entry. The court will find that the charges against the defendant were dismissed on July 1st of 2025, following the defendant's successful completion of intervention in lieu of conviction. There are no criminal proceedings currently pending against him. The charges are eligible to be sealed, and the defendant's interest in having these records sealed is not outweighed by any legitimate government need to maintain these records. So I'm going to grant your request, sir, and file the entry right now. Done. All right, congratulations. Mr. Laux is going to hand you a copy of the entry that I just signed, and you need to keep that for your records. Okay, sir?
Yes, sir. Thank you.
Thank you. Good luck.
Mr. Fisher?
How we doing today?
All right, these are case numbers 03CR20920, 05CR21970, the State of Ohio versus Christopher Fisher. You are Christopher Fisher?
Yes, sir.
All right, Mr. Fisher appears before me today on his request to have an expunged of these charges that he was convicted of. Ms. Nicholson, anything on behalf of the state?
No, Your Honor.
I know
Miss-
they're all pretty old. I
Yeah. Anything else you want to add?
Me, sir?
Yes, sir.
I mean, other than I was young and dumb, and you know, they are pretty old. I'm looking through here. I'm going to make sure that I did get everything. I'm kind of clueless on how the process goes, and it has been a long time since I've been in any kind of courtroom. So I just wanted to make sure that I did cover all my bases, basically.
Well, we can take a look at that in a second, but let me, with regard to the two cases that you did file under the 03 and 05 case, the court does find that the required time period is fast from the defendant's discharge from his criminal cases. There are no criminal proceedings currently pending against him. The offenses are all eligible to be expunged, and the defendant's interest in having these records expunged is not outweighed by any legitimate government need to maintain those records. So with regard to these two cases, I'm going to expunge them.
Thank you, sir.
Just need to add my signature to this entry and file it.
Actually, it feels weird being in a courtroom after all this time.
Yeah.
Your Honor, I think he filed under 3 case numbers.
Yeah, there was some.
03 CR 20920.
There was some that ranged.
Okay, well, hang on a second. Let me just do this first, because my docket only shows 2. But let me just jump to that in a second.
You're right, though. There was one that was ranked concurrent, I believe. That was kind of like I had to come back in another day and get those papers printed out.
Okay, so there was,
Well, so I don't know if he filed in all three. There
Okay,
was
let me look
three
at,
that
all right,
Officer
I see that there's three here. Let me just match them up here. 20920, that's been filed. 21970 was filed. Then there's a 22232, right?
Yes, and he did file a request in that case. I just looked.
All right, it's not in the
How weird, how was it?
22232. But it looks like he's eligible in that one as well. So let me just
Correct.
let me pull that one up real quick.
That's what I said. I just want to make sure my bases were covered because I know there was some confusion with the one case being ran with the other. When I was sentenced to prison, they had put, I had a really bad spell in my life back then, and it was a lot of it piled up real quick over the course of a couple months to a year. I'm glad Judge Flannery did what he did when he did it, because I'm looking at a lot more time.
Okay, and so under case number 05CR 22232, the court is also going to grant the request, make the same findings with regard to his eligibility, the passing of time, and that his interest in having these sealed is not outweighed by any legitimate government need to maintain the records.
Thank you, sir.
So I just got to, I didn't do, oh.
Your last one for the day?
No.
No.
After this?
We've got a pretty full docket, so you are not the last.
You get a quick break from the next one.
Thanks, Tim. All right, all done. Congratulations.
Thank you so much, sir. I really appreciate it.
Yep.
Report on here, the Honorable Judge Judge Simpson.
As Nicole saying.
Report on.
Good morning. Good morning.
Go ahead, counsel.
Morning, Honor. Bruce Mayrain appearing on behalf of the plaintiff.
All right, Ms. Sales?
Good
Oh,
morning.
there she is. Good morning. All right, what is, this is a non-payment of rent case. What is plaintiff's claim?
Your Honor, at this time, plaintiff is owed $2,560 in rent and $198 in costs,
For a total of,
for a total of $2,758.
all right. And Ms. Sales, how are
Yes,
you
sir.
intending on getting, how are you intending on getting that paid?
Well, I'm trying to talk to family members right now. I've been in talk with my landlord, Jason, and we have been working out agreements. So far, he's been satisfied with everything. I have come up with $2,400 within the last month and a half to pay him.
The 2,400, has that been taken into account in the number you've given me, counsel?
Yes, it has.
Okay. So you're working on trying to get this? come
Yes,
up with
sir.
the
I've
funds
lived
and
it.
trying to get it paid.
Yes, sir. I've lived in this apartment for almost 7 years now. I've fallen on hard times this past year, and my landlord does know this, and we have been working on payment arrangements.
Have you reached out to Housing Access for Washtenaw County?
I did. The first time I did that, they denied me, but it was before I even had before any of this even happened, the court or anything.
So you might want to reach out to them again. I'm going to suggest that you do that today.
Yes, sir. I do have to go to
All
work today, but I will try my hardest to do that today.
All right. And what I will do is you're entitled to an adjournment in this matter. So I will adjourn this matter to December 26th,
Okay.
2025 at 2 p.m. Ma'am, that is an in-person proceeding.
Okay.
All right?
Oh, yes, sir.
Thank you.
Thank you.
Thank you. So am I done then?
Yep, you are.
Okay. Have a good day. Thank you.
You do the same. Zhenfeng Zhang versus Kelly Reddick.
Zahir is here.
Who?
Zahir.
Morning, Your Honor.
Good
I'm
morning,
Kelly
Ms.
Reddick.
Reddick. Go ahead, counsel. What is,
Your Honor.
this is non-payment of rent case. What is plaintiff's claim?
Your Honor, we're seeking 7 months of rent. The rental rate is 3,300 plus 1,750 in water bills. It's all been unpaid.
So I don't know what that means. Is the
Your Honor,
rent each month 3,300? How much total? does
3,300
she
per
owe?
month.
So what,
7 plus 7. 24,850.
and that includes her cost, the costs you're claiming?
Yes, Your Honor.
All right. Ms. Reddick, what do you have to say about that?
Your Honor, I wanted to let you know that I didn't, I got the, what is that, the summons, delivered to me last Friday, but I didn't get, like, the demand was in there with it, and it said, that the amount I owe is $19,800, but I never received that demand letter previously. It says it was mailed on November 13th, but there's no signature on the demand, but that demand letter says I owe $19,800, which I do owe past rent.
Correct, and that was done in November.
November 13th, it says it is the date that it says it was mailed, although there's no signature and I didn't receive it. But that was from November, that's the date it has on it.
That's correct. I don't have a signature on this either. Counsel,
On the demand, Your Honor?
on the demand, I don't have a signature on the copy provided to the court. She doesn't have a signature. She doesn't see it. She is really indicating she never received it. When I'm looking at this, it almost appears like that was never mailed.
Your Honor, I can certainly send the signed signature version to you. I don't know why you have a version that's not signed.
I don't either. But she's also claiming she didn't get it, and I don't know if she wants to run with that defense. Ma'am, are you gonna seek legal counsel on this?
I had talked to a lawyer previously from Michigan, Southeast Michigan, but I
Yes, ma'am.
I can't hire one. but they did give me some, like, talk to me.
Okay. Well, what I'm gonna do is I'm gonna give you a week to try to figure out what you may want to do on this case.
Okay.
And then the court will have to figure out what it does with, I mean, because you've indicated didn't receive the notice and mine is not signed as to its proof of service. So I think at some point the court might have to make a finding on that. But
Your Honor,
again,
I can certainly send into the court the signed version. I don't know if there's a mix up in the filing, but we definitely signed it.
okay, I don't know either, counsel, but I'm not, this is probably not the hearing that I'm prepared to necessarily deal with that, but, I would just indicate that the complaint is S/slashed with your signature. However, there is no signature on the notice at all.
Well, we'll get an updated version filed, Your Honor. I know for a fact that we have it signed.
Well, I don't know that. All right, so I'm gonna adjourn it out to December 26, 2025 at 2 p.m. Ma'am, that is an in-person hearing. All right,
Thank you, Your Honor.
Your Honor, that's December 26th at what time?
2 p.m.
Your Honor, can we request that the money be placed in escrow of the non-payment owed?
Well, under the court rule, I'm not far enough out that I can order escrow. I can reserve the issue of escrow, but I can't order that whole entire amount be paid into escrow because that would be in violation of the court rule.
Thank you, Your Honor.
Thank you. Huron Vista versus Sabrina Jackson.
Good morning, Your Honor. Attorney Samantha Sprague-Pate, 1931, appearing on behalf of the plaintiff.
Good morning. And is she here?
Yes.
Miss Jackson?
Yes, I'm here.
Okay, there you are. I do need a camera.
Okay.
Counsel? Oh, thank you. What is plaintiff's claim in this case?
Yes, this is a non-payment of rent. This is the first hearing. There's currently past due rent in the amount of $5,340 and court costs in the amount of $239.40 for a total due owing of $5,579.40.
All right. And Miss Jackson, how are you intending on getting that paid?
I am currently working on that. I was just furloughed from my job on December 1st. And I've been having issues with my unemployment claim. And prior to me being furloughed, why the back rent was so high, I was getting like a quarter of my pay due to hour reduction. So I did reach out to Hawk, and I was not eligible at the time because I had received assistance when I was going through issues with the last apartment when Arbor One was condemned. So I was eligible for that as of January. So I am reaching out for assistance with that. I have been in constant contact with Sheena as well, which is the property manager.
Okay, you were an Arbor One tenant?
Yes, sir.
When did you move in here?
I moved into Huron Vista February 17th. My apartment was condemned, I want to say in September, but I moved into Arbor One in May of 2024.
Right. Okay. And you, when you were dealing with the Arbor One case, and I don't have it in front of me, were there any funds that you placed into Arbor One escrow with the court? Do you know?
No, not at that time, but I moved out in February and my rent was paid up until January. Through my job, I opened a case because I paid services, and they denied me of funds which I was anticipating, which was for November. And they were not corresponding with my lawyer at all. So I wasn't getting the funds from that. And then like my funds being cut from work, it was just a series.
Okay, I understand, but all right. So I just needed to know whether or not there might have been funds at the court out of those cases here, but it doesn't appear that they are.
Okay.
All right. So you're gonna either need to work something out with the landlord, try to find some assistance, or do something else. Yeah, in the case, I'll give you a week to try to figure that out and figure out what you're gonna do in this instance. I'll adjourn this to December 26, 2025 at 2 p.m. That's an in-person hearing.
Your
And
Honor.
Yes,
Is it possible to request an alternate day?
always.
Thank you.
Why?
Conflict.
Hold it.
Scheduling conflict.
Isn't Christmas over?
We've just begun.
26. Christmas is over. Midnight, it's done. Right? That's what I'm thinking. But what? Okay, I can give you another date because, but it's January 9th.
That's fine, Your Honor. Thank you.
So it work? All right.
Thank you.
All right. It'll be adjourned to January 9th, 2026 at 3 p.m.
3 p.m. Sounds wonderful. Thank you so much.
All right. Thank you. And I love Christmas, in case anybody is trying to say that. Okay. So I know that's what will come out of that. Huron Vista versus Charday Payne.
Attorney Samantha.
Clayton, can you hear me?
Yes, sir.
As well as Becky from the apartment complex.
Okay, I don't need it. Thank you. Wow.
The file number here is 252210LT, entitled Stonehouse Apartments versus Taya Layton. Miss Layton failed to appear for her hearing. I think it was December 1st. And she's filed a motion to set aside the default judgment. In order to set aside a default judgment, you need to have a meritorious defense and good cause for not showing up. I'm not sure we have either of those things here. The default entered on December 1st. We found that she owes $4,054 in rent, $131 in other costs, $194.20, for a total of $4,379.58. Or she was subject to evicted after December 11th. She filed this motion to set aside the default December 10th. So, Miss Layton?
Yes, sir.
I think you're mostly asking for a delay rather than, do you deny that you owe $4,000 worth of rent?
No, I don't deny that. I just really wanted to get that court date basically rescheduled because I didn't mean to miss it. Like I said, I'm usually good about getting on my court case and everything, but I had all that stuff happen with Indiana and then the accident that I just had court for with you the other day. So I just got very overwhelmed and lost track. My notebook that I had with the date on it got misplaced out of my car. So by the time that I did find out what day it was, they said, okay, well, you can file the motion against it, but I didn't have $20 yet, which is why I got filed on the 10th.
All right. Well, do you have a plan to either pay the rent or move out?
Yeah, so Neighborhood Inc. is doing my intake today at 3:00. So she said since I filed that motion, because I went in that week when you guys had already had that motion filed. So she said since I have more time now, she can do my intake, and then I filed my SCR. So I have everything filed in a motion for that. And I go today to talk to speak more with her, but she said that she was glad that I did come in because I can get the help. So she's doing my intake at 3 today, and then I find more out.
All right, well, let me tell you a couple of things. In order to cure this, you have to pay the entire amount of the rent. Partial payment will not prevent the writ of eviction. And on January 1st, another month's rent is going to be due. So you're going to owe about $5,000. So let's say Neighborhood Inc. gives you $3,500. You're still responsible for paying the balance, or you're still subject to being evicted. Absent this motion you filed, you would have been subject to eviction December 11th. And now we're 8 days past that date. It is easier to keep a good tenant in there than to move one out and move another one in, but they have a waiting list. They have people waiting for your apartment. And the people tell me every week I would move if I had somewhere to move to. So having said all that, Mr. Fleeman, do you have a position on this?
Your Honor, my position is that in the absence of a meritorious defense even having been listed on the form, I'm not sure why this was scheduled for a hearing. But because it was scheduled for a hearing, we now find ourselves at December 19th, a full month after the first hearing and a couple of months after the thing was filed. And when, as you very correctly point out, January is right around the corner. We're going to be at roughly $5,400 at that point. And I don't know of any agencies making that type of a payment. And when we were here last time, she was waiting on a nursing job. No, when we were here on November 17th, she was waiting on a nursing job. And I don't know if that job came through, but I don't see any way that this is going to get caught up. And I think essentially Ms. Layton is just buying time for the sake of buying time and costing the landlord more money, in the form of lost rent that they are never going to see again. So as such, I would ask that the order of eviction be entered now.
Well, I'm not trying to buy more time. I also just had a lot going on, like I said. So I was trying to actually get the assistance that you guys tell us to try to get. So, and I didn't get that nursing job, but I do have a job lined up for specialized staffing. I go in today once I found a reliable babysitter. So it's just a lot going on. I also have my 3 kids, and I was left with just being the responsible sole parent to just them, which is why I got behind anyway. So.
All right, well, there's 2 problems, Ms. Layton. One is you don't have a meritorious defense. You owe the money.
Yeah, I know.
So that's one problem. You're supposed to submit an affidavit of meritorious defense, but I'll set this for hearing anyway on a day Mr. Fleeman was going to already be here. We had the first hearing, as you mentioned, in November, and then we had the second hearing December 1st. So the first issue is there is no meritorious defense. The second issue is there's no good reason for failing to appear other than you forgot. If you were in the hospital or you were incarcerated someplace or that sort of thing. But so they're asking me to deny your motion to set aside default at the time to grant it, which means they could seek to evict you today. I was hopeful perhaps you'd at least give till the first of the year to seek the eviction. But they haven't actually filed.
Stop, please.
All right. Are you with me?
Yeah, sorry. I had to get my son situated.
Are you with me, Kira? All right. The motion to set aside the default is denied. I would suggest you have Neighborhood Inc. help you to see if they can help you pay your rent on another place. But there's problems. When you get evicted from a place like this, it may make you ineligible for other federal subsidized apartment placements. So this is a real deal. And Mr. Fleeman, as a practical matter, probably no eviction is going to take place until the first of the year anyway. It's Friday. I haven't got the writ yet. I'm here Monday and Tuesday. I'm gone the 26th. I'm not sure what Sergeant Morris's plan is. But Ms. Layton, the motion to set aside the default is denied. The plaintiff is going to submit a writ of eviction.
So is there a way that,
Neighborhood Inc. is not going to give you $5,400. My suggestion would be you take what resources you have and try to find another place to move to. But they followed the steps. They've been trying to get you to move since September. I don't know when the notice to quit was filed.
September
And
11th.
so no rent has been paid September, October, November, December. And as I said, they have a waiting list of people that want to move in. So
We'll do Markham first. Sorry, I thought you were in here. All right, this is the case of the state of Ohio versus Sirius Markham. 25 CR 42899. Present before the court is Mr. Markham, right?
Yes, sir.
Represented by Ms. Kirby, and we have Mr. View from the prosecutor's office, Mr. Gash from probation. We're here today, Mr. Markham, because your attorney has filed a motion requesting something called intervention in lieu of conviction. We abbreviate this as ILC. If I grant this motion, which I'm inclined to do today, you're going to enter a plea of guilty to these charges. But instead of finding you guilty and imposing a sentence, I'm going to accept your plea of guilty. I'm going to order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan for outpatient treatment. You're going to follow the rules. You're going to refrain from the use of drugs or alcohol during the treatment period. If you do all of those things, this case is going to end without a finding of guilt. But if you don't do the things that you're supposed to do, or you begin using drugs or alcohol during the treatment period, then I can revoke the intervention in lieu of conviction and proceed to sentence. Do you understand that?
Yes, sir.
How old are you?
I'm 19.
How far did you go in school?
My senior year, but I didn't finish.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
No, sir.
Are you a United States citizen?
Yes, sir.
Other than what we talked about today, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. It looks like on the second page, there's a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Ms. Kirby before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of guilty to 1 count of receiving stolen property, 1 count of carrying concealed weapon, 1 count of improper handling of a firearm in a motor vehicle. The charges are all 4th-degree felonies, punishable by up to 18 months in prison and a $5,000 fine. There is no mandatory prison in the case. Even if you were not successfully complete the ILC, I don't have to send you to prison, but if I do send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the ILC. Is that what you want to do?
Yes, sir.
Mr. View, has the state been in touch with the victim regarding the case?
Yes, Your Honor. We've had discussions regarding the case and prepared to proceed with ILC.
All right. What are the facts?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on July the 24th of 2025 in the city of South Lebanon, Warren County, state of Ohio, that the defendant was in possession of a stolen firearm and that loaded firearm was concealed within a backpack and within a motor vehicle.
Anything on those facts, Ms. Kirby?
Nothing on the facts, Your Honor.
Mr. Markham, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes, sir.
Do you understand the rights you're giving up by entering plea?
Yes, sir.
What's your plea?
Guilty.
Going to accept your plea of guilty. I think it's been made in a knowing, voluntary, and intelligent fashion only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I do have some reservations about granting the motion for ILC. Mr. Markham, I am going to grant the motion, but based upon the PSI, you don't seem like that great of a candidate for ILC because it doesn't seem like you want to do the things that ILC requires. Intervention in lieu of conviction is more work than a criminal conviction, and being on probation, you have to comply with the treatment plan. You have to do the things that you have to do. I think we're going to probably find out pretty quick whether or not you are serious about this. And if you're not serious about it, then we're going to get you over to the general book probation because I got people who need Officer Gatch's time and resources much more than you do. So we're going to adopt a treatment plan for outpatient treatment. I want you to do 10 hours of community service sometime within the next 30 days. I'm going to impose upon you the standard rules of ILC, and I'm going to delegate to your officer the ability to make special or additional conditions as they see fit. You are going to be under the general supervision of the probation department. You're not on probation, but those are the folks that supervise my ILCs, and we're going to include random drug testing. Anything else? All right, good luck to you, Mr. Markham.
Thank you, Your Honor.
Case of the State of Ohio versus Stephanie Newport. This is case number 25 CR 43030. Present before the court is Ms. Newport, represented by Ms. Kirby. We have Mr. Harris in the prosecutor's office and Officer Gatch for probation. We are here today also, Ms. Newport, for a hearing on ILC. Again, we abbreviate this as intervention in lieu of conviction. If you plead guilty to this, I'm going to accept your plea of guilty, and we're going to adopt a treatment plan. As long as you follow the rules, then we're going to be okay. How old are you?
44,
How far did you go in school?
graduate,
Are you able to read and write English?
yes,
Are you under the influence of drugs or alcohol?
no, sir,
Are you taking any medications?
yes, sir.
What are you taking?
I'm on the Sublocade shot. I'm on a lot of vitamins. I'm on depression meds and
Let me ask it this way. Are you taking anything that would interfere with your ability to understand what we're doing here today?
No, sir,
Are you a United States citizen?
yes, sir.
Other than our discussion about ILC, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir,
I have a document entitled Change of Plea and Entry. It looks like on the second page there's a signature above line defendant. Is that your signature?
yes, sir,
Did you review this with Ms. Kirby before you signed it?
yes, sir,
Are you satisfied with the representation that you have received in the case?
yes, sir,
You're going to enter a plea of guilty to one count of attempted aggravated possession of drugs. This is a fourth-degree felony punishable by up to 18 months in prison and a $2,500 fine. And if I were to send you to prison because you violated your ILC, I don't have to, but if I were to do that, the maximum penalty also includes an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. They have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights, you're going to admit that you did it, and we're going to get on to the matter of the ILC. Is that what you want to do?
yes, sir,
Mr. Harris?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment as amended to an attempt that on or about July 24th of 2025 in the city of South Lebanon, Warren County, Ohio, defendant Stephanie Newport attempted to possess methamphetamine in the amount of 5.76 grams.
Anything on the facts, Mr. Kirby?
Nothing on the facts, Your Honor.
Ms. Newport, did you hear those facts?
yes, sir,
Do you admit they are true?
they are,
Do you understand the rights you're giving up by entering a plea?
yes, sir,
What's your plea?
guilty,
I'm going to accept your plea of guilty. I think it's been made in a knowing, voluntary, and intelligent fashion, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm going to grant the motion for intervention in lieu of conviction and order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan. I'm also going to place you into the REACT program. That's a more high-intensity level of supervision. I'm going to order that you enter into, successfully complete the Genesis program and any aftercare that they have. And you're going to be under the general supervision of the probation department, and that's going to include random drug testing. Is there anything else we need to do? Anything that I forgot?
No, Your Honor. Thank
Your
you.
Honor, she's on an ankle monitor. We would request that be removed. She's having some swelling in her legs and medical issues that are making it difficult with the ankle monitor. She's also under the supervision of Montgomery County and Xenia Municipal. So she's not running. She's not going anywhere. She will show back up to her appointments.
All right, I am going to go ahead and remove her from the monitor today because originally we had talked about her being released into the community on a monitor. She's a Genesis. I'm good with that. And, you know, we have to figure out what our next step is after Genesis. I mean, Genesis is a really good program, but it's not as long as some of our other programs. So we need to transition into something that's going to work. Officer Evans and the REACT people will help you with that.
Yes, sir.
Okay? Anything else?
Yes, sir.
All right.
Thank you.
Good luck to you.
Thank you.
Ohio versus Marshawn Billingsley. This is case number 25 CR 42741. Present before the court is Mr. Billingsley, represented by Ms. Kirby, and we have Mr. View from the prosecutor's office. We are here today for a conference, but it's my understanding Mr. Billingsley is going to enter a plea of guilty to obstructing official business, receiving stolen property, and some criminal tools. Is that right?
That is correct, Your Honor.
Mr. Billingsley, how old are you?
24.
How far did you go in school?
23, Your Honor. My bad.
Oh, that's okay.
Say it again.
How far did you go in school?
I got my high school.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No, Your Honor.
Are you taking any medications?
No, Your Honor.
Are you a United States citizen?
Yes.
We've had some discussions about your case. If you enter a plea of guilty to these charges, I'm not going to sentence you today because I don't know enough about you and I don't know enough about this case yet. What I'm going to do is conduct a level 2 pre-sentence investigation. We're going to come back here in about 8 weeks for sentencing. I've told your attorney that this is the kind of case where I am very likely to put you into my community control program. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will? I have a document entitled Change of Plea and Entry on the second page. There's a signature above the line defendant. Is that your signature? Did you review this with Ms. Kirby before you signed it?
Yes, Your Honor.
Are you satisfied with the representation you've received in the case?
Yes, Your Honor.
You're going to enter a plea of guilty to 1 count of obstructing official business, 1 count of receiving stolen property, 1 count of criminal tools. The most serious of those charges is the receiving stolen property. It's a 4th-degree felony, punishable by up to 18 months in prison, $2,500 fine. Also carries with it an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. Presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, you have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, Your Honor.
Mr. View, was the state able to confer with the victim in the case?
Yes, Your Honor. In regards to the stolen motor vehicle, we're prepared to proceed as per the plea agreement.
All right, what are the facts?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on June 13th of 2024 in Deerfield Township and in the city of Mason, Warren County, state of Ohio, that the defendant did obstruct law enforcement in the officers in their duties in a manner that created a risk of physical harm. In addition, he was in possession of a stolen motor vehicle, possession of a key cloning device with the intent to commit a felony.
Anything on those facts, Ms. Kirby?
Nothing on the facts, Your Honor.
Mr. Billingsley, did you hear those facts?
I heard.
Do you admit they are true? Do you understand the rights you're giving up by entering a plea?
I understand.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. Not going to go into the matter of the sentence today. Need to go back down to pretrial today, fill out the paperwork for the PSI. We'll see everybody back here in about 8 weeks.
Thank you, Judge.
All right, that's all.
Okay, all right, I'll see you then.
So I would stay in contact with my manager. Also, When you move, you need to turn in the keys and give your forwarding address within 4 days of moving in writing. You need to turn in the keys and give your forwarding address within 4 days of moving. As it is, the matter's been deferred. You were eligible for eviction after December 11th. It's now December 19th. And as a practical matter, probably no eviction would enter until the 1st of January. So you've delayed it 20 days or so, but they've been asking you to pay the rent or move since September. And the 11th hour and the 59th minute and 59th second, the clock just hit midnight. And Mr. Fleeman, you can submit a writ of eviction. Ms. Slayton, I would call Neighborhood Inc. and tell them you need help finding a place to go. And I would suggest you stay in contact with your manager. But
So
that's the
is there
best I've got.
Is there
Yes.
a set date yet, or could I be out by the 1st, or is there something that I could work out with their attorney to, if I'm out by
All
this
right, well, I
date?
don't know. Are you willing to give her until January 2nd to vacate?
I really have nothing planned out yet. Just me and my 3 kids.
Yes.
Your Honor, I think you're right. As a practical matter, even if I send it in today and you sign it on Monday, I don't believe that the officer will be there by that time, but he might be there right after 2nd. That's possible. I do not know what his schedule is, and I don't have authority to give any additional time. And Your Honor, you made a really good point. This started in September. This is not a surprise. This started a long time ago. So I think that the plaintiff is probably not going to give me authority to stretch it out longer. They've waited long enough.
All right. Well, you can assume that perhaps nothing's going to happen at least until after Christmas. But you're right. This has been delayed for months. So Ms. Layton, you should, with some urgency, try to and stay in contact with your manager. It's highly likely they'll give you until January 2nd.
Can you
It's
stop
a lot
on
easier
the
to have
phone?
somebody
No.
move out than have somebody move in, but this didn't go away because you ignored it, and here it is. So I wish you the best. Stay in contact with your manager. When you leave, you need to turn in your keys and give your forwarding address in writing within 4 days.
So as of right.
Yes, that's a set. Thank you, Elaine. All right, well, let's add those figures up. That's 169.86 plus 5,790 is 5,959.86. 10 days from today. Today is the 19th. It would be due December 29th. Are subject to being evicted by default. I do not have a judgment in here, Mr. Nossinger, if you'd send me a judgment. One thing I saw here, Mr. Lowry, there's no lease. Did you have a lease with her?
Just verbal.
Don't do that anymore. The verbal lease is not worth the paper it's not written on. You've been in the landlord business long enough, you know that you need a lease to protect yourself, but is she still there? Well, she has 10 days to vacate or pay, or she's subject to being evicted. I'll note Luke will provide judgment.
It'll be here before the judge.
Well, you can just email it when you get back to the office and I'll sign it.
Thank you.
All right, thank you. Is that it for you this morning, Luke?
Yep.
All right, sorry about the glitch, but we got through it.
Oh, no problem. No problem.
All right, and I thought that I would be sending another case to Judge Pattison. All right, let's get back on schedule. Ms. Yancey's here. Her matter was set for 9:10. It's now 9:25. The first matter is entitled V Squared Ventures versus Alexis Williams and any other occupants. Ms. George and Ms. Sanders are both second hearings. But Miss Williams, I need to tell you what your rights are as in a landlord-tenant case. Once again, we don't have Meg Bauer from Legal Aid joining us. I'm not sure where she is this morning. Miss Williams, you have a right to hire a lawyer. If you cannot afford one, the court would give you information about getting assistance from legal aid. We sent that information to you with the original packet. You could also seek other legal advice. You have a right to have your case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or make the demand in writing within 5 days and pay the jury demand form. Jury demand fee, which is $50, unless the judge waives the fee for an inability to pay it. If your landlord has asked you to be evicted because you haven't paid rent in a residential rental, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, or help for veterans. If you are a veteran, you may be eligible for some emergency housing assistance. You do not need a judgment against you to receive help from the places listed above. A copy of the summons and complaint from your case are sufficient. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested in that, the court can help set it up. So far, that's never happened, but maybe it will one day. You may be able to reach an agreement with the landlord. It means the case would get dismissed by the filing of what's known as a conditional order of dismissal. And if we're able to do that, Ms. Yancey could prepare that form for us. Let me make my note here. Ms. Yancey has provided a judgment information form. We used to call these the Christine Yancey form because she was the first person to start to do it, but they make my life much easier. Ms. Williams, they contend that through December, you owe $2,764 in rent and late fees. That would include a partial for October and a late fee, November's rent and December's rent. 3 months of utilities, $180, a pet fee of $960. There are 8 dogs in this little apartment?
There's a dog,
No,
Your Honor,
sir,
they have puppies, so yes, there's that many dogs.
Oh my.
No, sir.
There's 2. Anyway, they've got $960 listed as pet fees and court costs of $120.69 for a total of $4,046.29. What's your plan, Miss Williams? Do you plan to move or would you wish to stay there?
We have a couple things left that we need to get out, and after that, we're planning on being gone. After today.
All right. So you would vacate by today. That's certainly
Your Honor, we would certainly be willing just to resolve this matter short of having another hearing and incurring more attorney fees for my client. We would certainly agree to a consent judgment that that they would vacate by the 29th, which is what the normal 10 days would be. And then if they do, then we can do a dismissal. If they don't, then we can ask for the writ.
all right. So Ms. Williams, would you agree to vacate, either pay $4,046.29 or move out by December 29th?
Yes, I agree to move out.
All right. When you do move out, you need to turn in your keys and give your forwarding address in writing to the landlord within 4 days of your moving. I'm not ordering a money judgment at this time. I'm ordering that you pay $4,046.29 or move. And you're agreeing to move. As I told the last lady when you were here, In a landlord-tenant matter or civil matter, when you're not represented by an attorney, you have 3 days to move to set this judgment aside. If you misunderstood or disagreed with the settlement we're placing on the record, you have 3 business days to tell me and ask to move that aside. But I'll show that you consent to move by December 29th, 2025. They can apply your security deposit to back rent, utilities, and other fees. That's why it's important that you turn in your keys and give your forwarding address in writing so they can send the security deposit notice to you. They may at some point sue you for money damages. And if they do, we'll have a hearing where we take testimony under oath to figure out how much is due, particularly regarding this dog fee. But at this point, you're planning to move, so you're not going to pay that money anyway.
Yes, sir.
All right. I'm going to send you a copy of this judgment. It shows you have until December 29th to move and December 29th to appeal it. Or pay $4,046.29. So you don't have to come back. There will not be a second hearing. You simply agree to vacate. If you don't vacate, they can ask for an order of eviction and the sheriff can put you out, but I don't think that's going to happen. When you do finish moving out, give the keys and your forwarding address to the manager and you're good to go. Do you have any questions?
No, sir.
All right, you're good to go.
Thank you.
Thank you. Ms. Yancey, it seems I've been going to a lot of funerals lately, and I guess I'll probably see you at one tomorrow too.
Yes, Your Honor, unfortunately.
All right, thank you. I'll see you next time.
Thank you.
Man who lives in my neighborhood, really good guy, died accidentally, probably from a propane heater in a hunting blind. And his visitation and services tomorrow. And Ms. Yancey's also friends with him. He's the same age as me. All right, we've got Mr. Fleeman should rejoin us here. 9:15 was Carmia George, and Baugh is, I'm not sure what time that is. Miss Baugh isn't here. So we're waiting for Mr. Fleeman to rejoin us. That's 9:20. We're behind schedule. Legacy LLC, 9:15, 9:20, 9:25. We have 3 cases with Mr. Fleeman. He may be caught in another court. So everybody just stick with me. Oh, it says I've got 6 people in the waiting room. Let's admit them all, including Meg. They're all here.
Excuse me, Judge Middleton.
Yes.
Meg Bowers is asking to get joined in. She's been in the waiting room.
She's here. Just brought her in.
Thank you.
All right, you guys have been in the waiting room. My apologies. We just finished our last case. We're about 15 minutes behind. But our next matter on the calendar is the Legacy versus Carmia George. Mr. Fleeman is here on behalf of the plaintiff. This is what used to be known as Waterfront Apartments, I believe. Mr. Fleeman, we were here December 5th, continued the matter until today. At that time, $3,119.20 was due. She had applied for emergency assistance. What's the status here today?
Your Honor, I'm looking at the same ledger balance, $3,119.28 specifically, but yes, the balance has not changed.
Ms. George, what's your position?
I was able to talk to my landlord because I forgot the number that the lawyer gave me, but we came to agreement that I was moving out and that I should have the keys turned in by this Sunday and payment arrangements for the remaining balance.
All right.
So, Your Honor, to that effect, I would be willing to enter this as a conditional dismissal, basically just changing it from a non-payment to a sentence saying that she will vacate on or before, what is that, 12/21? Yeah, 12/21. And that I usually include language in the further orders that says that any money issues between the parties will be resolved in the normal course of business and pursuant to the Security Deposit Act. So she can obviously handle the payment arrangements directly with management.
Ms. George, is that agreeable with you?
Yes.
All right, same circumstance. We just agreed to a conditional order of dismissal by consent. I don't know why you would object to a dismissal, but you have 3 days to inform the court if you wish to set this judgment aside because you misunderstood or disagreed with what we placed on the record here. Mr. Fleeman will send me an order.
Okay.
Do you know where you're moving to?
Not currently, but I am like moving all my stuff out into storage at the moment.
All right, well, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. And then they can send you the information regarding the security deposit.
Okay.
All right, thank you. Do you have any questions?
No, I do not.
All right, you're good to go. Good luck to you.
Okay, thank you.
All right, next up is Legacy versus Marie Baugh. Ms. Baugh is here. Ms. Baugh, can you hear me?
Yes, sir.
All right, this is a first hearing and I need to advise you of your rights as a tenant in a landlord-tenant proceeding. You have the right to hire a lawyer. If you can't afford an attorney, you could ask legal aid to see if they could provide assistance to you. And representative from legal aid, Meg Bauer, has joined us this morning. I had her vanished in the waiting room for a while till I actually got her in here, but she's here with us. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or make the demand in writing within 5 days of today and be prepared to pay the $50 jury demand fee unless the judge waives it for your inability to pay. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, and that's what this circumstance is, you may be able to get emergency housing assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, or if you're a veteran, you may be able to get assistance from a veterans program. The last case, we did what was called a conditional order of dismissal. If parties can agree on the terms, perhaps a conditional order of dismissal could be reached and Mr. Fleeman would prepare the form. We also could refer the matter to mediation if both parties are interested, to seek a mediated settlement. And if parties are interested, I could pursue that. And the manager is here as user. I'm sorry, I've forgotten your name. What's your name, sir?
Your Honor, he's actually the
Daniel.
manager for Edgewater. Sorry.
Edgewater.
Oh, Edgewater. Anyway, let me get your name. What's your name?
Daniel Artley, Artley.
Yes. My kids went to school with Devin Artley.
Yeah, that's my nephew.
All right, and so what is the circumstance here? Ms. Baugh has provided a copy that she has requested rental assistance from some agency. I'm not clear which one it is. Ms. Baugh, you're asking for some emergency financial help?
Yes, I applied through DHS to get some help to pay my back rent due to the fact that my paycheck was delayed for the month of November. This is the only reason I am behind 1 month.
Well, let's find out how much we are behind. Mr. Fleeman, what's the arrearage here?
Your Honor, I'm looking at a balance of $1,390 for rent. The court costs were $183.49 for a total of $1,573.49. I do see where Ms. Baugh has made a couple of payments on November 19th and November 25th. I don't have any other payments after that. So if she has made a payment in the last couple of days, I may not have it on my ledger.
All right, Ms. Baugh, so they say you owe $1,390 in rent through December. Your rent is $995 a month. So it's 1 month and part of another month. So you're asking for some emergency assistance to help with that. We're gonna bump this out a bit. Have you heard anything back?
I was denied from DHS, but I reached out to my employer because we have emergency funds for situations like this, but they only help with $500 to be exact. I have a little bit of money.
You understand that?
Yes, sir.
Okay. For some reason, we don't have the assessment that was completed while you were in the Warren County Jail, so I'm going to order an updated assessment. Your probation officer will set that up for you. You are to complete that assessment and follow any recommendations of that assessment. Do you understand?
Is that the
Drug and alcohol mental health assessment?
Yeah, I took that when I was.
I know, but we don't have
Right.
have that assessment. So I'm ordering.
My PO said that he had just got it a little before in court. I talked to him a little bit.
Who did?
My officer.
Officer Lee,
Yes.
I'll have to speak with him. And see
Okay,
if I can-
if that assessment, if we have that assessment, then you won't have to do a new one, but you order, I don't know what the assessment says, so I'm ordering you to comply with whatever that assessment recommends, okay?
Okay.
All right, I don't have it yet. All right, you order to complete the theft class, order to complete thinking for a change, you ordered to get your GED. Where are you working?
At Chipotle.
You working full-time?
Yes.
Okay. I want you to continue that. Restitution is ordered in the sum of $4,999.96 to Best Buy. That is joint and several with your co-defendants. You're also ordered to have no contact with your co-defendants, and you are trespassed from all Best Buys. Means you're not allowed to go into any Best Buy stores. You understand that?
Yeah.
Okay. The court does find that you're indigent for the purpose of any fines, costs, or other financial sanctions other than the restitution. Now, you're also subject to a discretionary period of post-release control, which means if I send you to prison on this charge, upon your release, the adult parole authority may choose to supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, that can all be provided to you at no cost. You understand? You have any questions for me? Okay. Head back down to court services. Your probation officer is going to want to talk to you for a little bit this morning. Okay, sir? Okay. All right, good luck.
Thank you, Your Honor.
See you, Nate.
Want me today to pay some towards this balance. I just need time to get caught back up.
Who's your employer?
I work for Menards and I also work for HomeJoy, a home health care provider.
Well, unless whoever is willing to give you $500 of emergency housing to help, more companies I wish would do that. Well, the law says I have to adjourn this matter for at least 7 days, and next Friday I won't be here. So that means we're adjourning this into either the 29th of December. Let's see what we've got on the 29th of December. Mr. Fleeman, you don't seem to be here on that day. Let's look at January 2nd.
Actually, Judge, I was just looking at my calendar. It looks like I have a 1:35 for a Sturgis Place.
On the 29th?
Yes, sir.
Yeah, there it is. All right, let's set this for 1:40. Continue this 10 days.
And it looks like Miss Strong will be handling that one, at least as of right now. So she will be appearing on that one. I'll be out of town that day.
All right, Ms. Baugh, if you get $500, I say blessings to you. That'll help work on this arrearage. The only thing that cures this is paying the entire amount. So we're going to revisit this on 10 days from now on December 29th at 1:40. If they get what they asked for, they would then get 10 additional days before they could ask for the writ of eviction, which would be January the 8th. And even then, they don't have to evict you on January 8th. Now, our hearing is going to be on December 29th. On January 1st, another $995 worth of rent is going to be due for January. But let's see what circumstance you're in next week. Now, you're free to come in here live. I'm not afraid to have you come in the courtroom, but I use that conference room in case I need to put you in a breakout room with legal aid or with the attorney for the apartment complex, and I can't do that from the courtroom, so we do it from that room. You and I have met before, and that conference room can be helpful. So we're going to continue this to the 29th of December at 1:40. You can come in live once again, or you could Zoom in. I would also suggest that you touch base with your manager and let them know what your intentions are. But let's defer this as the law requires. We'll go 10 days rather than 7.
Okay.
That'll be December 29th at 1:40. Do you have any questions?
No, sir.
You can stop out at the counter and they'll give you the notice, which will save you the mailing, but we'll address it further. Good luck with your continued request for some emergency help. but they can agree with a way to help you get the rent paid
Your Honor,
if they choose to. So I'll see you in 10 days on the 29th of December. Mr. Freeman?
can you throw me in a breakout room with Ms. Baugh for just a quick moment so I can get a phone number? To stay in
Yes.
contact? I'll be very brief because I know you got another one for me.
Yes. He's gonna get your number so he could call you and discuss this and maybe seek a resolution. So when the button comes up that says join, click that and you'll go into the breakout room.
Hello?
Ms. Baugh, can you see it?
I see the button, but
Click on the one that says join.
I hit join, but it's not doing
Could you
anything.
go help her?
Yes. Come in.
Good morning, Mr. Apps. It's been a while since we've seen you.
Good morning, sir. There's a guy on Court TV every now and then looks just like you. He seems to be having a good time. Do you have any idea who that imposter is?
He's probably having more fun than I am. I saw you on TV in front of your building that caught fire. That wasn't much fun.
No, the police tore it down.
Yes. Oh yeah, they raided
There was
it.
there was a guy held up shooting at the police for some reason. I can't imagine why. And so rather than shoot back, they just tore the building down. I was on channel. I was on ABC, NBC, CBS. I was written up in the Detroit News, and eventually the city sent me a check. So all is well.
Good. Okay. Yes.
I have a situation. We have a hearing at 1:30.
We do? Okay.
Yeah, Ruby sent it to you Monday to sign. I didn't catch it. So we need to have it signed also.
I want to go to that thing. Yeah.
Yeah, I think that's all set before. Set it out on the day of.
Did we block the calendar?
No, we did not. So I said, they're gonna be happy. What done with these?
Yes.
Okay, something about that.
All right, Mr. Freeman has rejoined us. We're turned to Edgewater versus Shamika Sanders. The file number is 252356. Let me make my note. Mr. Artley is here.
And Judge, Ms. Sanders did contact our office. She spoke with our intake attorney at the beginning of the week. Case was assigned to me yesterday, and although we normally wait to speak to the client before presenting through case review, I did present it through case review yesterday, and the decision was that we should appear on behalf of Ms. Sanders as attorney of record.
All right.
Sorry, Tara.
All right, you have represented her in the past.
Hold on.
This is originally filed. We were here on December 5th. Parties were put in a breakout room and talked at some considerable length. This was filed as a termination of tenancy. The defendant is habitually late on her rent, and the plaintiff simply wants to terminate the tenancy. She's been there for some time. We had some struggles with her kids and with her, and this is the second hearing in the matter. Mr. Freeman, what's the position of the plaintiff?
Your Honor, the plaintiff's position has not changed. They still are seeking possession of the unit, but I have not had any further discussions with Ms. Sanders or with Ms. Bauer, obviously, because she just got involved. I will say for the record, and I presume the court record reflects this, but I don't know if Meg would know this yet. I did file an amended complaint to
Yes.
reflect that prior civil action, because after our first hearing, it occurred to me that I had not indicated there was that prior action. So just a housekeeping matter.
Yes, I did. I read it and the clerk had noted that it had been filed. So Ms. Bauer, what's your position?
My understanding is that the defendant's rent is currently paid in full and potentially with credit on the account. That Ms. Sanders is a client of Pivotal, and that this is not doesn't warrant possession for the plaintiff. There is a de minimis harm here, and an effort to go out of their way to make someone homeless when we don't need that right now. They haven't expressed a significant harm as a result of the payments being late, and whether there's a need to request an accommodation or not. In light of the relationship with Pivotal, I would need to investigate that further, but believe it's a possibility. Also understanding that I have not had a conversation with Mr. Fleeman and am only relying on what I can read from the pleadings and our notes from the conversation with Ms. Sanders.
Yes. So they wish to terminate the tenancy. You get contacted by the defendant. This isn't your fault. You show up today and say, oh, by the way, I'm appearing, and oh, here's a couple of potential defenses. And so it's like, she's habitually late on her rent, and they're tired of it. On or about January 2nd, a default was entered. Conditional dismissal was issued as rent was not paid. March 12th, a conditional dismissal was issued granting another stay of the terms of the agreement. Rent was not paid. January 13th, a demand for possession, non-payment of rent. February 11th, demand for non-possession, non-payment of rent. March 11th, demand for possession, non-payment of rent. May 13th, demand for possession, non-payment of rent.
Judge, may I address these?
I'm not done yet.
Sorry, I thought you were.
May 13th, conditional delinquency. June 11th, demand for possession, non-payment of rent. Met with the management counseling regarding payment. On or about August 12th, demand for possession, non-payment of rent. So that's what long history triggered all this. Over and above the other issues. So Mr. Fleeman or Mr. Artley, do you concede that is rent current?
I do not know, because in a termination case, I don't normally ask for a ledger.
Yeah, once
Daniel, are you
you
able to
file a
tell?
termination, you can't accept any rent. So the notice to quit was filed in October sometime. So we probably don't have October, November, or December's rent paid.
Judge, my understanding is that she has a credit on her account right now.
Yeah, her rent is up to par right now.
All right.
Also, Judge, with regard to the first conditional dismissal you mentioned, that was actually scheduled for a hearing with you. You cited in favor of the defendant. Attorney Fleeman and I proceeded to further negotiations, and that resulted in the March settlement. So the allegations in 16 and 17 are only a part of the picture.
And Your Honor, that is correct, that there was a second conditional dismissal. I don't believe that we negotiated for that one. I think that was as a result of a hearing, but I could be wrong on my recollection. But in as much as that case was dismissed and stayed dismissed, then the prior violations are fair game for this case as well, which is why I did the amended pleading, is that to let the court know, and that yes, so that continual delinquency stretches all the way back to 2022. And I would also say for the record that the specific federal regulations for rural development spell out, material noncompliance and other good cause. But one of the few things they actually spell out specifically is continual delinquency.
Judge, if this is related to my client, I object to it appearing. I don't know.
Oh, just a minute. Miss Blanquette, you've stolen my screen. Or Mr. Louis Blanquette, you're screen sharing your screen, and I'm not sure how you hijacked it.
Yeah, I didn't think you could do that.
I'm going to remove you. All right. So we have the rock and the hard place. Defendant doesn't wish to move. She is a client and may be entitled to some accommodation. The landlord has reached the end of their rope, filed this action. She now has representation. You didn't say it, but are you asking for a stay or a continuation of this?
I did not. I suppose conceivably there could be a Park Forest situation that would warrant a dismissal right now. However, I don't think it's in Ms. Sanders' interests to have another case filed against her. So I would ask for an adjournment so that Mr. Fleeman and I can.
Why would she be entitled to a dismissal right now?
If her rent is paid in full with a credit, then.
But this is filed as a termination of tenancy, not a demand for non-payment of rent.
So unless the last payment that brought her in full preceded the notice to quit, then there would be receipt of rent subsequent.
All right, I got you. So you're contending that the plaintiff has accepted rent after filing a termination of tenancy.
That is correct, understanding that I have not myself seen the ledger. But Mr. Artley did represent to the court that her rent is current through today.
In Your Honor, I believe there is language in the notice to quit, though I'm not able, or the attachment to the notice to quit, though I haven't put my finger on it yet, that specifically addresses the Park Forest issue by stating that any rent payments received after this date will not serve to waive or bar plaintiff's notice to quit. That would be in a case that came subsequent to Park Forest. Bray versus Smith, I think. Something versus Bray, maybe.
As an officer of the court, the case he is thinking of is Aspen.
That's it.
I don't know the full citation. There are exceptions to that decision as well. Let's look at page 6. I don't recall seeing that when I looked at this last night, but it is 7 or 8 pages. So
yeah, right.
All right. Well, you're not asking me to dismiss the case at any rate. So, and there's no need for an escrow order because her rent is current. I could do an escrow order for January. How much is the monthly rent?
Daniel, I'm gonna relate.
$58 a month.
Judge, can I confirm with Ms. Sanders that that's accurate? I thought it was 26.
Ms. Sanders, how much do you believe your monthly rent is?
Right now, it is 58, but when I last went to court, it was supposed to be 26, but it never was 26. I ended up paying 58 from then all up until now, and I just got a new sign in saying as of January, my rent dropped down to 34. And so I am currently paid for this month and half of next month already.
All right, well, there's no need for an escrow order. Everybody who wishes their rent was $58 a month, raise your hand. This has got big consequences. You're not gonna ever find a place, certainly not as nice as this, but any place for $58 a month. For reasons I don't understand, you're late month after month after month after month, which I think may have to do with carrying forward past arrearages. Now your rent is paid in full. They wish to terminate your tenancy. We've got this issue about acceptance of payment after termination of tenancy has been filed. Mr. Fleeman alleges there's some sort of exception in the lease that I haven't looked at. And Ms. Bowers here to profess your defenses. For the complex, it's like, well, we got rid of Miss Sanders and there's somebody waiting to move in. For you, it's like you're homeless, you're unable to get other subsidized housing because you got evicted from this place. And so it's a lot more consequence to you than it is to the plaintiff. But whatever you've done has irritated them enough that they wish you to move out. So I'm gonna set this into the future, and I'm not gonna do an escrow order because the rent is minimal and she claims much of it has already been paid. Oh, yuck. I'm gonna set this for 11 o'clock on January the 9th. Let me see here. Or is.
I am available at that time, if that's where it lands.
I have a really ugly termination of tenancy trial set in the afternoon. I have to catch a plane that night. Mr. Fleeman, are you available on January 9th at 11?
I am, Your Honor. I was just looking at that. Yes, I am available at that time.
I'm hopeful that with two competent attorneys, you guys can discuss this and see if we can come up with a resolution. We'll discuss it further on that day. That'll also give us a little time after the first of the year. And all right, that took us a lot longer than I had hoped, and we're still got other cases to do before we get to our general civil matters. But does that complete your obligations, Mr. Fleeman?
That does. I think that's my only remaining case. Yes, that's all I have. So.
All right, thank you. We're about a half an hour behind, but we'll catch up here shortly. All right.
Thank you, and have a good holiday.
I'll see you. All right, Ms. Sanders, you're good to go. I think maybe Shorty. Oh, there you are. Stay in contact with your manager and with Meg from Legal Aid, okay?
Okay.
We'll address this again in January.
Okay, thank you.
All right.
And Meg, just so you know, is she gone?
No, I'm here. I'm here.
You just moved on the screen. I'm after today, I'm going to be gone for the next couple of weeks. I mean, I'll have access to email, but I won't be back until January 1st or 2nd, something like that. So.
Okay. I'll try to give you a call this afternoon.
Okay. Thank you.
All right. Good for you.
You're good to go,
All
Daniel.
right.
Thank you.
For you who are here for general civil, stick with me. I got a few more cases to catch up. We've had a couple clinkers, but let's take up Amanda Hunneman versus Tina Hart. Are you Tina Hart? Yes. You have a seat right over here. Good afternoon, Ms. Hunneman, or good morning.
Good morning.
Let's see who else is here. Is Russell Sword here?
Yes, ma'am.
Yes, he's also present. You guys are here in a landlord-tenant case. Your landlord has asked you to move. Tina Hart, they want to terminate your tenancy. Mr. Sword, I think yours is a non-payment of rent. They want you to pay the rent or move. As such, you have certain rights. Mr. Apps, who's your client? That would be I'm not sure which one Mr. Apps is on. All right, anyway.
Your Honor, Gary Apps usually covers general civil matters
No, he's also a landlord, but Gary, what case are you here on?
Judge, I think he's frozen. I was going to send him a text.
Yes, he is. Maybe it's really cold there after they tore his house down.
Yes, Darling Fox.
All right, Gary, you're here on the Darling Fox case. Is that correct?
I am, sir. Your screen froze up and I had to reboot the Zoom. I apologize if I was not available for a moment there.
It's a matter of what perspective you have. From here, your screen froze up. So anyway, you had a nice expression on your face while you were frozen, but you're back with us now. All right, let's address both defendants, Ms. Hart and Mr. Sword. Both of these are termination of tenancy cases. They want you to move out. You have a right to hire an attorney. If you can't afford one, you can ask legal aid to represent you. You have a right to have your case heard here in St. Joseph County where the property is located. That's never been an issue, but we're all here in St. Joe County. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or make the demand in writing within 5 days of today and be prepared to pay the $50 jury demand fee unless the judge waives it for your inability to pay. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, that is a different circumstance. This is a termination of tenancy. They want you to move. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested, the court can help set that up. And you may be able to reach a mutual agreement, by which case they would file what is called a conditional order of dismissal. And if that does occur, we could assist in the preparation of that. Ms. Hart, I've been talking with Ms. Hunneman in the context of a different case, and we were aware of this case. You're living in her house at Coolwater Lane in Colon, and she wants to sell the house, and she can't sell it with you in it, so she wants you to move. What's your position?
I have a couple options, but it's been really hard to, I don't have a car and I don't have a phone, so I have to borrow those. And they've been restricting access for people to come down to even get to where I'm at. So like I can't use a phone. Like this whole last week, I've had no phone or no way to get out of their place.
Why is that their fault?
Well, they were blocking the drive. They've pushed things in front of the drive. So like when you come down the drive and then around to where I'm in the basement, like they've been telling people that I'm not there, and sending them away. And it's like, they have to not, I can't hear anybody. I'm way back in the basement. So like if somebody knocks on the door, they got to go through the first door to get to another door to get to me.
Well, Ms. Hunneman, is there a lease?
No.
No, sir.
And you told me that she doesn't pay any rent,
Right.
but she's just there.
She has.
All right, well, obviously you're gonna have to move out
Yes.
because they can't sell the house with you in it.
I just need a little bit of time.
All right, well, you're gonna get some. They gave you a notice to quit in October. She's probably wanted you to move out since September. But people would move, but they don't have anywhere to move to. I hear it every day. And so you're living there without a lease. They wish to sell that. They have an offer to buy it and they're waiting for you to get out so they can sell it. It looks like a very nice home. Ms. Hunneman, when did you last receive any rent?
September 27th.
We're here today for a pretrial. It's my understanding Mr. Smith's going to be entering plea of guilty to F5 possession. We're going to go forward with sentence today. Is that accurately stated?
Yes, sir. Yes, Your Honor. Yes, Your Honor.
Mr. Smith, I know we've been through this not too long ago. How old are you?
I'm 39.
How far did you go in school?
11th grade.
Are you able to read and write English?
A little bit.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
No.
Are you a United States citizen?
Yes.
Other than a 6-month concurrent sentence, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
The document entitled Change of Plea and Entry. On the second page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Gibbs before you signed it?
Yes, sir.
Are you satisfied with the representation you've received in the case?
Yes, sir.
You're going to enter plea of guilty to 1 count of possession of a fentanyl-related compound, 5th-degree felony, punishable by up to 12 months in prison, $2,500 fine. Also carries with it an optional period of post-release control of up to 2 years. Your constitutional rights have not changed at all since we went over them in August. You still have the right to make the state of Ohio prove that you're guilty of this unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. I'm going to admit that you did it. We're going to get on to the 6-month sentence. Is that what you want to do?
Yes, sir.
Mr. Harris, what are the facts?
Your Honor, if this matter proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment as to count 1, that on or about July 20th of 2025, Washington Township, Warren County, Ohio, defendant Chad Smith was found to have 0.5 grams fentanyl on his person. This was after being picked up on a warrant and prior to transport.
Anything on those facts, Mr. Gibbs?
Nothing further, Your Honor.
Mr. Smith, did you hear those facts?
Yes, sir.
You admit they are true?
Yes, sir.
Do you understand the right you're giving up by entering the plea?
Yes, sir.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. We have 0 days of jail time credit, no restitution, right?
Correct, Your Honor.
Mr. Harris, anything additional from the state?
Your Honor, my understanding is he was sentenced under 25 CR 42653 to 11 months. And it's my understanding the intention of the court at this time was to run that concurrent.
Mr. Gibbs?
Yes, Your Honor, that is our understanding as well.
I mean, the fact that the paperwork hadn't caught up to us since then, Mr. Smith, we knew about this at the time. I still think that you need to go to a treatment facility, someplace like Monday or CCC. I assume you haven't changed your mind in that regard, right?
I would rather not.
All right, I'm going to sentence you to, is there anything else you want to tell me?
No.
All right, I'm going to sentence you to 6 months in prison, concurrent to the time that you're already doing. I'm not going to impose a fine. I am going to impose the costs and the optional period of post-release control of up to 2 years. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript or to pay the costs. They will all be provided to you at no charge. Good luck to you, Mr. Smith.
Thank you. Thank you, Your Honor.
Thank you. All right, thank you, Johnson. Have a good Christmas. Thank you.
Well, this isn't about payment of rent. I'm not asking you to pay any money. But she needs you to move out so she can sell the house. And in the old days, you would get 10 days from today to move or be subject to being evicted. In the current world we live in, we have to adjourn the matter at least 7 days. I won't be here next Friday. So we're going to continue this matter till December 29th.
And my purchase agreement does end on the 31st. So we will be able to resolve this by then, correct?
Well, I don't know the answer to that. Someone they want to buy the house by the end of the year. They can't sell it with you in it. I guess you could sell it anyway, but I don't know whether so I'm going to adjourn this for 10 days. Then you would get another 10 days to vacate before they could get the sheriff to come put you out. So what her preference would be, that you be out by December 31st. Is that a possibility?
Possibly. I just have to line up people to move me and stuff too. Even if I put all my stuff into storage, they've been flicking the breakers off. I've had no heat sometimes. No way to cook, no lights in the kitchen. I woke up with the door open and freezing one night and woke up in the morning. I almost had to go to the ER. I've got a lot of medical stuff going on with me, but I don't want to cause her any discomfort. It's just.
All right, well, the law says I have to continue this to January 29th, December 29th.
Okay.
So we'll talk about it. She's got people chomping at the bit. Now you can't, or your significant other can't screw around with her electricity or her water. So that violates the Landlord-Tenant Relationship Act. But what's known as a tenant at sufferance. They've been trying to get you to move out since at least October.
Mm-hmm.
It's now October, November, December. You haven't moved. So they go through this process where the judge tells you have to move or the sheriff comes, throws your stuff out. Otherwise, nobody would ever move. They'd say, well, I'm looking for a place. I can't move. This puts a hard deadline on it. But it's causing a big hardship for her because she has an offer to sell it. And the buyer doesn't want to buy it with you in it. And
slamming my name on social media.
Well, she wants you to get out. She wants to sell it. You're living there. You're not paying any rent. You don't have a lease, and she wants you to move.
Why would you throw their name out on social media and say don't rent to them? If you really wanted somebody to get out, you would just.
I don't know the answer to that. I don't know why people do what they do on social media. The world would be a better place if it didn't exist, but it is a thing. So, Ms. Hunneman, I have no option other than to continue the matter until December 29th. We're already jam-packed for that day at 2:30.
Okay.
You said at 2:30?
Yes, before you leave, you can stop and get a notice. Ideally, she would like you out by that day. This may undo her sales agreement.
And I would lose.
She's got
$5.
I'll say that again.
I would lose my earnest money if I do not complete this purchase agreement. If things don't go through by the 31st, I'm going to lose $575 that I'll have to pay again.
All right. So you could be liable for that. All right, I don't know what's going on with your lights or your heat or your door or your accessibility. I've instructed her not to interfere with your tenancy, even though they don't want you there and you don't have a lease. You're a tenant, even if it is a tenant at sufferance, and you have certain rights. But your failure to move is causing financial hardship to them and whoever is interested in buying this house. So we're going to revisit this. My request would be that you make every effort to get out of there by then, and we could simply dismiss the case. If not, the sheriff's going to come put you out. You're going to have an eviction on your record, which will make it very difficult for you to get into the next place. Reason for leaving last tenancy, evicted, and they aren't going to want to rent to you, and you may be ineligible for subsidized housing. So we'll revisit this. You go out to the counter and they'll give you a notice. December 29th at 2:30. Does that work for you, Ms. Sonneman?
Yes, it does.
All right. Hopefully you're in the same house. It's a big house.
Yeah.
On the lake or access to the lake. But let's see what we can accomplish by December 29th. I'll see you at that time. If you go out to the counter, they'll give you the notice right now.
Okay, thank you.
All right, thank you. Mr. Chevernack, I haven't forgotten you. We're going to get to you in just a minute, but next we're going to take up Darlene Fox versus Russell Sword. This is file number 252588. LT. Darlene Fox owns a property at 16812 Moore Park Road, and she wants Mr. Sword to move out. Filed a termination of tenancy back in August. Attorney Gary Epps is here on behalf of the plaintiff, and Mr. Sword is here in the conference room. Mr. Sword, you filed a proof of application for rental assistance, the Michigan Department of Health. She doesn't want you to pay the rent. She wants you to move.
Did you see that the notice to quit has different dates? The one she gave me was August, and the one the courthouse gave me was September. Those don't even, I didn't get the September one. That was.
Well, why didn't you move out?
Because she did me wrong. I've been there for 5 years and I've never been late on my rent, ever. My daughter went and tell a lie for her at church, and then she wants to kick us out. She burnt my daughter.
Say that again.
My daughter went and tell a lie for her at church, and she wanted to kick us out. She burnt her huts. She took my tree stands.
Your daughter did what at church?
She went and lied for Darlene at church. And that next day we got served that notice to quit.
All right, well, there may be some allegation of a retaliatory eviction, but you have a month-to-month tenancy. And you had a lease, and then it expired, and then it became a month-to-month. So she filed a notice to quit on October 21st, giving until the end of September to move. You didn't move, so they filed this action. That's how it works. The last lady, she wants to sell the house.
That August one that she gave me wasn't checked out right either. The box wasn't checked. I didn't get that September one until the court papers.
Well, you got the August one.
That wasn't checked.
Well, let me ask this, Mr. Sword. Have you made any provision to find a place to move to?
Yes, I have.
All right, tell me about that.
I got a couple applications out in Portage.
Meg Bauer is here from Legal Aid, and you may be able to consult with her. You're claiming some sort of a retaliatory eviction, that somebody said something to somebody and that's why they want to evict you. To some extent, she can choose to evict you. Let's say that you bought a four-wheeler and she doesn't like four-wheelers. So she wants to kick you out because she doesn't want that four-wheeler in there. She owns the house. You have a lease and you have a month-to-month tenancy, and she gives you a month's notice in August. So now we're in a situation where she filed a termination of tenancy August, September, October, November, December. You've lived there for 5 months without paying any rent.
I was a month ahead on rent, and she never.
All right, well, so you're 4 months behind on rent. Because once she files a termination tenancy, she can't pay. So you have a free tenancy right now. Maybe that's money to pay first month's rent somewhere else. But Mr. Apps, I've been driving the bus here. You want to add anything else regarding this?
No, you're doing exactly what I would have said. It's a month-to-month tenancy. We've asked them to move. There may be some exceptions to the Park Forest rule that I'm unaware of, but I stick by it pretty strictly. Don't take any rents after the termination date. So we've not taken any rents after September 30th. And here we are.
All right, we're going to continue this, Mr. Sword, to December 29th, 2025 at 2:40 p.m. If they got what they asked for on December 29th, you would have until January 8th to move out or be subject to being evicted. Sheriff could come put your stuff out in the street. If you vacate before that time, we wouldn't need to have a hearing. But they've been asking you to move since August, so this didn't sneak up and bite you in the ankle. So we're going to continue.
If I may interject, Your Honor, there is a supplemental complaint for the rents through when he finally does move out. So if he does move out, you said there isn't
money damages.
Yeah, you said there isn't a need for a second hearing. There may be to determine the amount of rents possibly due.
All right, thank you. I didn't make a note of that. That's on me.
I apologize for interrupting.
Filed, yes. All right, so there's also the issue of all the unpaid rent. She wants you to move and she wants you to pay September, October, November, December, and January's rent. If you move before January 1st, you wouldn't be liable for January's rent. But we're going to be discussing it. Who else lives there?
My daughter.
What's her name?
Riley Sword.
Heidi Sword?
Riley. Riley.
Is she an adult?
No, she's a kid. 17.
How old is she?
Just turned 17.
All right, so moving entails new school districts, that sort of thing. So we'll address this further on December 29th at 2:40. If you go out to the counter, the clerk will give you a notice. I see that you filed for rental assistance, but they aren't going to give you any rental assistance because this is a termination of tenancy case. All right. Good luck, sir. Mr. Apps, thank you. We'll address this further. I didn't ask. Does that date work for you?
I'll make it work. Yeah. Happy holidays, all. Thank you.
All right. Thank you. All right. Mr. Shevernak's been waiting patiently. Let's call his case. We're about a half an hour behind, and I apologize. But that happens sometimes. Freedom Mortgage Corporation versus Valerie Van Orden, Paul Van Orden, and all others. We were here last November 14th. The matter was continued until today. Attorney Timothy Chevernak is here on behalf of the plaintiffs. Granted possession November 24th. The defendant then came in and filed a motion to set aside the default. And it doesn't appear that anyone's here on behalf of Valerie Van Orden. Mr. Chevernak, what do you know about this?
Your Honor, the defendant, after filing this motion, contacted our office within a few days of this hearing today, basically reciting what she indicated in her motion, that she and her, I believe her husband, live in their vehicle, that any property left behind they don't have any interest in. And that was pretty much the substance of the phone call, which is also basically what they put in their motion. We would just ask for the motion to be denied due to the non-appearance today of the defendant on this matter, and the judgment stands so my client can remove the substantial amount of personal property still left in the house.
I will sign the order. The motion is denied. Defendant failed to appear. Original judgment stands. Zoom is a wonderful thing. Although you're in the waiting room for about 40 minutes, you didn't have to drive all the way out here, hire somebody to cover this hearing. And I've granted your order. They aren't here. I'm not even sure they wanted the relief they were asking for. But the motion to set aside the default is denied and the original judgment stands.
Very good.
Very good. Thank you for your patience.
Thank you.
All right, we have two general civil matters, summary disposition cases. One is J.P. Morgan versus Jeannie Huster. And that would be Mr. Brian Groen, who always enjoys watching our landlord-tenant proceedings when he comes to visit. Good morning, Mr. Groen.
Good morning, Your Honor. You said exactly what I was going to say. I love landlord-tenant.
Just glad you're not in it.
I'm sure you do as well.
Yes, yes. Oh, they're.
Hey now,
This is a motion for
saying?
summary disposition. The file number is 251600. It's a substantial amount, $10,911.82. They didn't ask for any costs. The defendant is not here. By her answer,
Your Honor, the defendant has an attorney, Jocelyn Wee, and we did settle this with a consent judgment for the full balance with a collection stay of, I believe it was 90 days or 60 days. And we did email that to the court yesterday afternoon. So this is going to be resolved with a consent judgment. So we will not be going forward with our motion for summary.
I see it. They're electronic signatures. Jocelyn, we did sign.
To have a hearing on this allegation.
Yes.
You wish to waive that hearing based on your advice of counsel and admit to the violation?
Yes.
Okay, very good. The court's going to find that you have violated the terms of your community control. Despite this violation, the court is going to continue you on community control at this time. And I'm going to order you to serve your 30 days that I had previously ordered, okay? When you get done with that, you need to check in with court services. We're going to transfer your supervision to Cuyahoga County. There were some other things that the court ordered in your original sentencing, primarily restitution, but there was also substance use disorder treatment that I ordered that you need to complete, okay?
Yes.
Any questions? Anything else, Ms. Tranter?
Judge, are we applying that she has 4 days credit? Are we applying that to the 30 or do you want 30 fresh?
No, she gets credit for the 4 days.
Okay, thank you.
All right, Mr. Washington, anything else?
No, Judge, thank you.
Merry Christmas.
Merry Christmas to you. See you in 26 days. So,
26 more days.
did they count yesterday? No.
That would be calculated for today.
Okay.
She doesn't have a violation. Oh, I don't know. That's just what they told.
This is case number 25CR42920, the State of Ohio versus Toteny Jones. Ms. Jones is before the court with her counsel, Mr. Newberger. Ms. Tranter on behalf of the State of Ohio. There was a motion for intervention, lieu of conviction that was filed in this case. That motion is denied. Ms. Tranter.
My understanding, Your Honor, is that Ms. Jones is prepared to change her plea to guilty as charged for a grand theft felony of the 4th degree.
Mr. Newberger, is that accurate?
Yes.
All right, Ms. Jones, they're telling me that you're going to change your plea to guilty to the theft charge. Before we get to your change of plea, I am required to go over some things with you. Do you understand that?
Yes, sir.
How old are you?
31.
How far did you go in school?
12th grade.
Can you read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation that you've received from Mr. Newberger?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
Yes, sir.
I have in front of me a document called a change of plea. On the second page of this document, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, sir.
You feel like you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to a theft charge, a felony of the 4th degree that carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. The prison term is not mandatory. Do you understand the maximum penalty?
Yes, sir.
You're also subject to a discretionary period of post-release control, which means that if you are sent to prison on this charge upon your release, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
But as I've said, it's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control or what some refer to as probation. If you violate those rules of community control, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
Now, you are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty, and their verdict must be unanimous. Do you understand that? At that trial, you have a right to see and hear all the evidence that the state has against you with the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor at your trial. You're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of the charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that? Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial. This is how you wish to proceed.
Yes, sir.
Ms. Tranter.
Your Honor, in addition to the facts alleged in the indictment, this incident occurred during a time frame of April 25th through June 12th of 2025 in Warren County, state of Ohio. Defendant was a manager for the Deerfield Walmart store during that time. She was observed accessing the store's deposit box, using her code and grabbing money from the safe and putting it in her pockets and sleeves. Total loss to the store was $80,617.
Mr. Newberger, anything on those facts?
No.
Ms. Jones, did you hear the statement that she read?
Yes, sir.
Did you admit and acknowledge that what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up entering a plea of guilty, those rights we discussed?
Yes, sir.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we have discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Ms. Tranter, anything before I sentence her?
Nothing further, Your Honor.
Anything from probation?
Nothing further.
Mr. Newberger?
No.
Ms. Jones, is there anything you'd like to say before I sentence you?
Yeah. I need help. They said they would get me help at inpatient for drug treatment.
Okay. Ms. Jones, what is your plan? This case has been pending for some time now. What is your plan to pay off this obligation that you now have?
Get a job and pay it back.
$80,000. I mean, if I put you on supervision for a period of 5 years, $80,000 divided by 60, I'm guessing it's going to be about $3,000 some dollars a month, if my math is correct. And how are you going to pay that back?
Get a job or two.
Okay. All right. The court has considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. I am going to find today that you are amenable to community control, so I'm going to place you into community control for a period of 5 years. You will be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs, illegal drugs, alcohol, or marijuana. You're not permitted to use marijuana in any form. Do you understand me?
Yes, sir.
There's restitution owed of $80,617 to Walmart. You are trespassed from all Walmart stores. You're not permitted to go into Walmart anymore. You understand that?
Yes, sir.
I'm ordering you to serve 180 days in the Warren County Jail. You have credit for the 5 days you've already served. You are also, I'm going to find that you're indigent for the purpose of any fines, costs, or other financial sanctions, because I want this restitution paid. Now, you're also subject to a discretionary period of post-release control, which I just spoke about. Do you want me to go over that with you again?
Yes, sir.
All right. You have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, all of that can be provided to you at no cost. Now, I am remanding you into the custody of the Warren County Sheriff to begin serving your jail time. I'm going to have your probation officer looking into some sort of inpatient treatment. Now, if she arranges something, I will suspend further execution of the jail time while you are going through that treatment. You will be placed on a monitor while you're in that treatment. And then at the end of that treatment, I will determine at that time whether I will further suspend the 180 days. So you owe right now 175 days of jail. And I'm telling you right now, if you're going to go through the treatment, you're going to go back to the jail. I'll determine then whether I'm going to make you serve the rest of the days. But if you don't have a solid plan in place for this restitution, if the restitution is not going to get paid, you're most likely just going to be sent to prison and serve out your sentence there. Do you understand me?
Yes, sir.
Do you have any questions for me?
No, sir.
Are you pregnant? All right, this time there's the Warren County deputy standing behind you. I'm remanding you into his custody to begin serving your sentence. And you'll let me know about the treatment, right?
Yes, Your Honor.
One question, Your Honor.
Yes, sir.
If treatment becomes available, will the court, it's a lot to ask, but will the court absorb the cost of the GPS because she's got $80,000 to pay and she's got issues with other places?
I'll talk with the probation officer about that.
Thank you.
175 is what she owes. There's going to have to be an amended.
Yes, I'll just do 175 and somebody.
Yeah.
Thank you.
Thank you.
All right, Mr. Gibbs, Mr. Burke, you know.
This is, you ready, Doug? This is case number 25CR42932, the state of Ohio versus William Burr. Mr. Burr is before the court with his counsel, Mr. Gibbs. Ms. Tranter, on behalf of the state of Ohio, we are here for sentencing. Ms. Tranter, anything on behalf of the state?
Nothing further than what we discussed, Judge.
Anything from probation?
Nothing further, Your Honor.
Mr. Gibbs?
Yes, Your Honor, I would just like to note, in discussions with my client, he has repeatedly and very sincerely expressed his apologies for this situation and very deep regret. He is truly taken this as a wake-up call and a time to look forward. And he's also experienced some fairly serious health issues related to his cardiac health. And my understanding is that he has some level of a cancer diagnosis, somewhere in the treatment stage on that. Given all those, on the positive side, Your Honor, he has obtained a new job, which with much better compensation that's going to be starting in January, and is certainly looking to take positive steps forward from here on out.
Mr. Burr, is there anything you'd like to say? All right, the court's considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court does find that the defendant is amenable to community control. So I'm going to place you into community control for a period of 3 years. You'll be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs, alcohol, or marijuana. Do you understand? You're ordered to successfully complete substance use disorder treatment. You're ordered to complete the Thinking for a Change course. There's restitution owed of $16. You are trespassed from the Miami Valley Gaming. Do you understand that?
Yes, sir.
Now, my understanding is that you have claimed that you are a veteran. We cannot find any verification of that. Do you have a DD-214?
No, sir. I can't get it.
Why?
From my understanding, they wiped it clean.
All right. Without that, I cannot consider you for Veterans Court. I am going to order you to serve 30 days in the Warren County Jail. You have 0 days jail time credit. At this time, I'm going to stay execution of that 30 days pending report from your probation officer over the next couple of months to see how you're doing. And then otherwise, we'll have you schedule that 30 days with the probation officer. You're also subject to a discretionary period of post-release control, which means if you are sent to prison upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Tranter, is there anything else?
No, sir, thank you.
Mr. Gibbs?
Just, Your Honor, a quick request for clarification on the 30 days. Am I understanding correctly that it's stayed currently, and is that going to be stayed indefinitely if he's in compliance with community control?
Possibly.
Okay.
Possibly. Okay. Any questions?
No, sir.
All right. Your probation officer going to want to talk to you this morning. If you'll head back down to court services, please.
Hi. She's a cute. See you, Jonathan. So I would have to do like a I had no idea he was out. I was assuming.
We'll talk about it. Yeah, come on up.
He was running 1 for 1 when he was locked up, so
So we got.
May 13th was the date I was using
Fair enough.
for that,
Okay.
so.
Good to know.
Good.
These are case numbers 25CR42968, 25CR42977, the state of Ohio versus Duran Oldham. Mr. Oldham is before the court with this counsel, Mr. Brenner, Ms. Tranter, on behalf of the state of Ohio. Where are we going with these cases, guys?
Your Honor, I know the court's aware, we had been waiting on DNA to come back for several months. We did get that report. At this point, I will continue to have conversations with Ms. Trainer because I know the court's aware there's 2 separate cases. I think we have much more of a contention with the first case number than the second. I think we'll be able to come to some kind of a agreement on the second case number, but the first case number I would anticipate setting for trial, Your Honor.
What's the time issues on both cases?
Well, Judge, I had no idea that he was out, so I would have to do a recalculation of the time. I mean, previously he was being held 1 for 1. I had a tentative date of May 13th.
So he's still 1 for 1 though, right? Because he's out.
Well, that's true. So it's probably May 13th. I don't know that since he's out, if Mr. Brenner has any issue with signing a time waiver at this point.
Well, if it's May, if that's the time frame, we're going to set this. We're going to set you say the first one?
The failure to comply case, Your Honor.
All right, set the first case number 42968 for 2-day jury trial. I want those dates picked now. So, all right. Anything else, Mr. Brenner?
Your Honor, at this point, I would like to address the court. If the court would like a written motion, I will get that filed as well. My client's has been released on the GPS monitor. Obviously, there's a cost associated with that. My client's been looking for work, has not been able to find work.
Well, let me stop you. In that case, there is a alleged victim involved, and under Marcy's law, any modifications to the bond are required to give notice to the victims before the court hears anything on that bond modification. So I would like you to file a written motion. You have to give at least 10 days notice to the alleged victim in the case.
Okay? I will get that filed today, Your Honor.
Okay.
That's all.
All right. Anything else?
Not on this case.
All right, great. Thank you all.
So we're setting the other one for pretrial. Is that what I'm hearing?
So I think I'm thinking pre-trial conference.
But you're going to get a trial date.
Yeah.
And then
by Monday, the 22nd, okay? So get 800 into them, do another 800. How much is your monthly rent?
$15.88.
Okay, so you need to get another 800 in by, let's just say January 2nd. What that's gonna at least do is keep this number where it is right now, or right around in that ballpark, because I'm gonna adjourn this out into January, okay?
Okay.
But you need to make those payments and then figure out where you're gonna come up with the other, if Hawk's gonna help you with the other approximately 2,000. All right?
Okay.
Okay, January 9th, 2026, 3 p.m. in person.
Thank you, Your Honor.
January 9th.
All right, thank you.
Wait, January 9th at 3, you said?
Yes, ma'am.
Okay.
All right, thank you. Is that it for you, counsel?
It is. Have a Merry Christmas, Your Honor.
Yes, I will. And you have a Merry Christmas and enjoy the day after, apparently. All right.
Thank you.
All right, take care. Barnes and Barnes versus Sharice Christian.
That was Freeman for the plaintiff.
And Dylan Rose.
That was Freeman for the plaintiff, Your Honor.
Dylan Rose is here, actually. Yeah, defendant too.
Dylan Rose?
I'm here.
Okay, there he is. All right. What is plaintiff's claim?
Your Honor, this is $28.20 in rent, $295 in costs for $31.15.
$31.15. All right. And Ms. Rose, how are you intending on getting that paid?
I filled out an application through SCR, and I'm currently working. I just my car gave out on me, so I had lost my other job, so I had to find something in Ypsi. So I'm good now. I just need to catch up.
Okay. So just so that you know, if you filled out an SCR, you'll need to fill out the rental assistance form that came in your packet, supply that to the court by next Wednesday. Actually, I have to move that, don't I? You have to supply that actually by the 26th, next Friday.
Okay.
Because the court is closed those 2 days. So you have to supply that form. How many people are in your apartment?
Just me.
Just you? So
Yeah.
so that you know, there's only going to be about 410 if they give you the maximum amount of the award on an SCR.
Okay.
Okay. So just so
All
that
right.
you're aware of that, is there anything that you can pay in the interim next week?
I should be able to next week, Friday. I just
Okay,
I'm waiting for my first
how much do you
paycheck.
think you can? How much do you think you can pay?
600.
Okay, we'll deal with that. Also, you can contact plaintiff's office or your landlord, see if you can arrange something.
Okay.
All right.
Appreciate
I
it.
will adjourn this out to December 26, 2025 at 3 p.m. That's an in-person hearing, sir.
Okay. Thank you.
Thank you. Court calls case Spencer Collins versus Gendria Brown.
That was Freeman for the plaintiff.
We have her. I'm sorry.
He's there and he's just not.
Brown?
Yes, sir.
All right. Your name?
Gendry Brown.
All right. And what is plaintiff's claim in this case?
Including costs $89.67.25.
89.67.25. All right, sir. How are you intending on getting that paid?
Me and Mr. Collins have worked out a deal. I've owed that amount since September, October, but I've continued to pay my rent over the last 2 months. And so
are you indicating that you and Mr. Collins worked out an agreement of some type?
Yes, sir.
Mr. Friedman, you don't know anything about that, I take it.
No, Your Honor, not with this kind of balance.
Yeah, okay. So, sir, what I'm gonna do, if you're saying that there's an agreement, I suggest that you contact the attorney's office so that he can talk to his client about whatever this agreement was. I'll adjourn this out to the 26th, 2025 at 3 PM in person. So you need, if that agreement, if there is one, is somehow or another gonna have to be reduced to writing to resolve this, if indeed there is an agreement. All right, sir?
I've been paying my rent over the last 2 months. I feel like this case isn't about rent. But
Well, okay, I'll ask. What do you think it's about?
like I said, we came up with an agreement here. And the plaintiff has requested, several times that we keep this out of court. But I've had several open heart surgeries and I fell behind. And Mr. Collins have been, he's been great with working with me. But I think it's more personal because I've gone back to work now and I'm not always available for Mr. Collins. And, like I said, he's begged me to keep this out of court. And so this was like a knee-jerk reaction like this. This was very unexpected.
Then, sir, what I'm going to suggest, if you believe you have a claim regarding that you might want to contact legal services or an attorney to advise you as to what your rights may be as to any of that. All right?
Yes, sir.
But I'm adjourning this out 1 week to the 26th. And again, I might suggest that you contact claimants counsel to see if there is an agreement that can be worked out.
Yes, sir.
All right. Thank you.
Thank you.
Portage Pass versus Kyrie Armstrong.
Ellis Freeman for the plaintiff.
Armstrong? Oh, there. I think that's him. You'll have to unmute, sir.
Right here. Hello, Your Honor.
Okay. Hello. All right. What is plaintiff's claim?
Good in cost of 7374.97.
All right. And Mr. Armstrong, how are you intending on getting that paid?
I have a settlement coming in the mail soon.
You have, I'm sorry?
A settlement that I recently spoke to my landlord about. Settlement, a check coming in the mail soon to pay off that debt.
Oh, okay. So you're expecting money and you're going to get this all paid off.
Correct.
Do you think that's going to occur within the next week?
Not the next week, but at least probably by January the 15th is what they said. Actually, I've written.
Okay. Well, here's what I'm going to do. I'm going to suggest that you contact the attorney for the landlord, see if something can be worked out, if that's what it is.
Also,
the phone number will be.
Sorry, Your Honor. Also, the amount. Can you list the amount again that I owe?
It's $7,374.97.
I have a whole different amount on this paper here. I don't think that's correct.
I know, because that's probably through November.
Okay.
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 So I will adjourn this out. I suggest that you contact Mr. Friedman's office, see if something can be worked out. If you're receiving a lump sum payment, can get this paid. But I'll adjourn this to December 26, 2025, 3 p.m.
Yes.
3 p.m.
Can we do a later date if possible?
That you get 1 week, and I'm not going to do it unless the plaintiff is going to agree. And by his silence, it looks like he's not.
Okay.
So it'll be the 26th at 3.
Okay. Thank you.
Thank you. Is that it for you, Mr. Friedman?
That's it for this morning, Your Honor. Thank you.
For this morning. All right. We'll see you second in court. Court calls the case of Orchard Grove versus Patrick Anderson.
Good morning, Your Honor. Brent Tigger for the plaintiff.
Mr. Anderson?
Yes, I'm here.
Okay, he's there. All right, this is non-payment of rent. What is plaintiff's claim?
Right now, the rent to retain is $2,240.64. There's cost of $193 for a total of $2,400. $33.64.
All right. Mr. Ensign, how are you going to get that paid?
As expediently as possible. My hot water heater went out, kind of wrecked my house, so that took my lot rent. So now I just have to catch up.
Okay, so you don't know when you're going to get this paid?
I'm trying to get it paid by the end of the year, honestly, because, you know, I don't like being behind.
All right. Here's what I will do. Is there anything you can pay before next week?
Yep, I can probably put 500 on it today, probably another 5 next week.
All right, so 500 today?
Yep.
And then you think 500 sometime next week?
Yep.
All right. Suggest you try to do that. Well, I won't say do it by Christmas, but do it at least on the 26th. I'll adjourn this out to December 26th, 2025 at 1 p.m. That's an in-person hearing, sir.
Okay.
Thank you.
Thank you.
Orchard Grove versus Robert Lash.
Brent Ticker for plaintiff.
Robert Lash, they are not checked in. If you raise your right hand, you may proceed. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead, sir.
Thank you, Judge. At this time, we would move for a default possession-only judgment in this non-payment of rent case. Right now, the rent to retain is $1,556.32. There is cost of $193 for a redemptive total of $1,749.32, written 10 days.
Judgment to the plaintiff by default for possession. Redemption amount, any amount requested with the writ issue in 10 days. Orchard Grove versus Andrew Lair.
Brent Ticker for plaintiff.
Andrew Lair, not checked in. You may proceed.
Thank you, Judge. We would move for a default possession-only judgment. Right now, the rent to retain is $620.11.
It's me. I'm Andrew Lair. I'm
What?
Stephanie.
I'm sorry, you're who?
I'm Stephanie. I'm the one that lives there. Andrew Lair is the father of my kids. So it would be under my name.
We're aware of that, Judge. She is the current resident.
All right.
I'm sorry, I couldn't figure out how to
And so-
unmute. It took me a minute. I'm sorry.
It's okay. What is plaintiff's total claim?
Right now, we have $620.11 of rent, $193 of cost, for a total of $813.11.
All right. Ma'am, how are you intending on getting that paid?
I was gonna pay that. I actually talked to Patrice like 2 days ago, and I told her I'd have it on Friday, so I was gonna pay it today.
Today? You're gonna, okay.
800.
That's fine.
Do you have something you want to say to me?
Not you, no, no, sir.
You were in my courtroom. I don't.
I was walking away from your courtroom is what I was doing. I'm so tired of this system fucking me over is what I'm tired of doing. I really am, sir. It's not you directly. It's somebody else in this system. I
But when you
appreciate
are-
you. I respect you. But I am not going to keep letting this shit happen to me. I'm not. And other people. It's not you. It's somebody else in this system. That's all I'm saying. No disrespect to you. Have a nice holiday.
I am disrespected because when you use that kind of language in my courtroom.
Well, when I get mistreated by the system, you'd feel the same way, sir.
All right.
No disrespect to you personally.
But it
It's
is.
somebody else. Thank you, sir. I have freedom of speech, you know. Like I said, fuck 'em.
Has come and gone. Sorry.
We may need.
Come and gone. Oh, where is Tierra Norman?
She's vacationing on the back.
And should we get some copper tone back there or what? Do we need her out here? What is this? What are we doing for them?
We need a little bit of guidance here.
I look like Edgar Fonda.
This is an MTRP from the shoplifting case with a new case that has some prior history. We had a court hearing 2 Mondays ago or last
We have
Monday.
NPRP and a new case.
Right. We had a court hearing last Monday and she had car trouble and appeared here at about 10 o'clock instead of 9. I was gone, but she did show up. And you placed her into custody.
Yep.
So
I think that was one of the reasons.
So I had active warrant for her arrest.
Mm-hmm.
It wasn't because she was late. She also had another. It was for the NTRP.
Oh, yeah, for the FPRP. Yeah. And this case happened in June. And the MTRP wasn't filed until a couple of days before December 4th. In this case. But he had a court hearing on the 9th.
Yeah, she wasn't indicted until September 10th.
Right.
And
the MTRP was filed, I think, December 4th. They're asking.
Yeah, well, that.
And the next court date was December 9th. I mean, she had a court date on the 9th. She knew about the warrant and she knew that she'd have to take care of it. So I filed prior to the 9th a motion for the court to consider a bond.
Okay.
So
where you want to add?
Well, this is the holiday season, Judge, and where
most thefts occur. I know you. How many thefts are too many? In your indictment, how many prior thefts are alleged in your indictment? This is your life. You know more than all of us about your life. Let's see if you can guess correctly. How many theft convictions are in this indictment? Previous that you've been convicted of? How many? Ma'am? 9. 9. And then we've got the new indictment. And now the new motion to revoke probation. How many is enough, my goodness? Don't you think going to jail the first one would have said, oh, that's like sticking my hand on a burning stove. I'm not going to do that. But you're not just sticking your hand on it. You're embracing the burning stove. Now you're embracing it. It's like this is what you do. What you enjoy doing because you're doing a lot of it. And we had for at the very first one, some court, maybe probably wasn't, it was probably a kind of court. They made a deal about it. It was important. They said, hey, look, you're going to go to jail. Now you're going to a prison. You can go to prison now because you've had so many. When you steal a pack of gum, it's a felony. If you steal a pack of gum, it's a felony the rest of you. That's because you've gotten busy. But no, I can't. As much as I'm the gift giver, but at this time of year, no, it's like me sending a DWI person out there. This is where people steal the most and where they drink the most. And unfortunately, you are paying for your actions. You're being held responsible. And the people who follow the law, most people, they don't feel sorry for you. I mean, maybe the first time, okay, you made a mistake. Everybody makes mistakes, but this is your 10th mistake. They're saying this is your 10th one. No, you're what you are. It's turned into your personality until you can prove that you're much better.
And proving myself alone.
No,
I have to plead
no, I'm sorry. No, you're You were let me speak.
Yes.
9 convictions. Your last one is in this court on November 21st of 2024. So how did you celebrate that? A few months later, you commit a new one, and it resulted in this indictment here. So this is your 10th one. After we made a big deal about it, and you went right out, and didn't take you long before you were stealing again. But no, we're not. We're going to resolve this before. We're not. And there you are, Dillard's. Just stealing, trying to steal stuff at Dillard's, which is why the prices are so high at some places, because not Dillard's necessarily, but at some places, prices are high because the honest people who purchase things have to pay for the losses that result in higher prices because of the people who steal. And that's why jurors on thefts, they don't find it amusing because they're victimized by the prices. Generally, they're not criminals who are in the juries. That's why people hold people accountable. But no, your motion is to. I wanted a motion. Do you want? Well, when do you want the motion to revoke probation hearing? Soon as possible. You can do it.
Your Honor, we can enter a plea of truth.
She's not going anywhere. I'm not going to release her until I get onto the record all the underlying facts and then I'll make a decision. But this is a tall hill to climb. What do you want to do today?
Well, if
I'm denying the bond.
you're denying the bond, the case is the case in reference that I think it's clear what happened and the result of it. And I guess
you want some time though to put together something that can convince me that she's not that she should not be sentenced to the maximum.
We do have
You give a chance.
semi-agreement of the PAP 12 judge.
No, it's going to be this. No, no, it's 10. My God, it's 10. The message we send after 10 convictions is no, you're going to get a break. Oh my God,
Well,
that is a terrible message to send, especially at Christmas time.
Let me try this option, Judge. You're not buying it.
Do I look like Santa Claus?
I know. In order to push this along,
yes,
if she will enter a plea of truth to the new offense and then ask for a PSI report so that we could come back here and decide.
Okay.
And based on what you do, then the new offense would coincide with that.
All right. That's what you want to do.
That's what we want to do.
Is that right, ma'am? All right. Then we call 22-41231, the state of Texas versus Tierra Norman. There is a motion to revoke probation that has been filed as of December 4th, 2025. You were here with Mr. Burbank, your attorney, and the state's attorney and probation official. First of all, does the defendant waive any additional time she may have under the law to prepare? Because I think she's got a few more days here that she could wait.
Yeah, this offense happened in June of
Not talking about when it was
25.
filed.
I'm aware of that.
This was just filed on the 4th, and I give everybody 30 days after a filing to at least be ready for an announcement. But if you want to waive any additional time that you may have under the law for a preparation, Mr. Burbank, on behalf of the defendant, are y'all ready to move forward? And does the defendant waive any additional time she may have?
We do, and we ask to proceed. I believe that what I've done, you want to comp one, which is saying.
All right, raise your right hand, ma'am. Do you solemnly swear or affirm any statement you made during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? You have to speak out so we can. May we proceed in summary? This should be the formal reading. In summary, this motion to revoke probation alleges that that on November 21st of 2024, you were sentenced to 2 years in the state jail, and that was probated for 2 years in this criminal district court of Jefferson County, Texas. If you sentenced to 2 years in the state jail, probated for 5 years for the state jail felony of theft of service. Is that all true? Yes. Allegation 1 states you committed the offense of theft of property on or about June 30th, 2025, in violation of your probation order, which is what is represented in this new indictment 25 CL 1242, where you're charged with the state jail felony of theft of property. And I believe this is from the Dillard's department store in Beaumont. Is all of this true and correct? Are you pleading true to this allegation voluntarily and because it is true as it is alleged?
Yeah.
You understand that a voluntary and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation by preponderance of the evidence or greater. Your probation can be revoked, and you could be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today? I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. We're going to order an updated report from probation. We will return back on January.
It'll be either the last week of January or first week.
Can we get the last week in January?
Yeah.
As fast.
Please. Okay.
Yeah.
All right. And then all parties can add anything else you wish. Court will make its decision, and then we will take up the other case and see what direction that the pending criminal case for which the new motion to revoke probation is essentially based upon, what direction that may take. Do you understand what has happened today, ma'am?
Yes.
What is your plan on living honestly from here on? Are you committed to doing that? Yeah.
Just trying things for my baby.
But you're still stealing. I know you, but hold, let me see this. Yeah, hold on. You know, I'll ask you to be straight with me, but don't blame your little baby. I mean, your convictions date back 12 years. How old was your baby then in 2014? You can't blame it on your baby. Yes, you did.
It was basically toys for the child.
Yeah, I know, but what happened in 2004? I mean, you got 9 convictions ago. What was the reasons for those? You know, there's always a reason you can find out, but you have to follow the law. And it's just material stuff. I know, but
how old was your child?
I have 5, so my first one was 15.
Well, you're stealing to. You've got 9 convictions because you were getting toys for your kids. All those. No, we know better. Right, we'll see you. Okay, Ezekiel Johnson. He's where? Oh, he's okay. Rosalind. I can't pronounce his last. It's Pangia. That's they're in there. Okay, Reagan has that one too. Reagan has Cameron Smith. Reagan has Maximo Urbina. Brent, what are you doing? Resetting something here. New cases are on the way. Yes. Is that right? No.
Yes, sorry about that, John.
You okay there, buddy?
Yeah.
You're not celebrating early today, are you?
No, not yet.
Okay.
Yeah, no, I was getting this one.
Okay, so when do we want to reset Mr. Cleveland? Because.
We'll reset to the 12th, Judge.
Can we can we just set it for a hearing on that day?
Yes, sir, that's what it's set for.
Okay, we'll set it for an not just a hearing, but an MTRP hearing on that.
Yeah.
To resolve it. All right. Cleveland reset till next year for hearing on disposition. Edward Otremba.
Yes, sir. This one was reset from last week. You wanted to give him an opportunity to pay restitution. I believe he has been, Mr. Menard here is probation office that his people have been calling. He's currently in jail. Yeah, we had an agreement with Mr. Hand for 18 months. Court was not pleased.
Agreement with Mr. Hand.
Certain court was not pleased with the 18. Wanted to do 2 years. That one would reconsider the 18 if Mr. Otremba was able to pay, and I think he's been trying to do it. But he's dependent upon his people in Houston to make the payment for him. That's what we're here today.
Do we know anything about what's been done?
Yes, sir. He hasn't been able to pay. He had one of his friends that attempted to pay, but they didn't make any payments. He did make the attempt, but
All right.
no payment was made.
So then what do we just move forward here on the probation?
Yes, sir. I mean, he hasn't paid since February of 2016 is when he was.
Okay, so you ready to move forward on it for disposition?
I think, well, at this point, Judge, I mean, he's already pled true, so I don't know what.
No, I don't. I didn't know that.
Okay, well, I guess he was. Well, I guess it's.
You have to do that. This is failing to report. We have Edward Joseph Otremba, please. Hey, Brent, did you get all the Christmas shopping done?
Yes.
Last night I completed mine for last year. I just completed it for last year and I'm working on this year from here on.
They were able to get paid.
We now call 15-21847, the state of Texas versus Edward Joseph Otremba. You're Mr. Otremba. Yes, sir. Present with Mr. Turk, your attorney, and the state's attorney. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation, which was filed when I was just a child, August 10th of 2016? Had he been an absconder? He'd been an absconder, okay. And can we proceed in summary? This is rare. These are rare, but they happen. Okay, he was reporting, and then in 2016, he quit reporting, and then he was an absconder, which means he was kind of on the lam there. This was filed August 10th. There was a warrant out for him for 8 years. When was he arrested? Where have you been for 8 years?
I'm living the same address in Houston, Texas, sir.
Okay. Nonetheless, you're supposed to come to us. We don't have to come to you.
It's been October the 16th of this year.
Okay. So that was over 9 years. You had absconded. All right. And does he waive a formal reading? We can proceed in summary.
Yes, Judge.
In summary, this motion to revoke unadjudicated probation alleges that on February 8th, 2016, and by the way, raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Over here. That on February 8th, 2016, in this criminal district court, you were placed on deferred or unadjudicated probation for forgery. Is that true?
Yes, sir.
Is it state jail felony?
Yes, sir.
Yeah, state jail felony. Yeah. Allegation 1 states that you failed to report to the Jefferson County Probation Office upon release from, oh, you never reported.
No, sir, he was released in June.
You were released on June 7th, 2016 from the jail, and you were required to report immediately, as all prisoners from who were in custody, who were released and placed on probation, to report immediately or as soon as possible thereafter. And that was over about 9.5 years ago. You failed to report on or about June 23rd, 2016, July 5th, 2016, July 13th, 2016, and was not heard from by the probation office. And all of this is in violation of condition 4 of your deferred or unadjudicated probation order, which states that you must report as directed to the probation office and obey all rules and regulations of the probation office. Is that allegation true and correct as it is alleged?
Only one part of it is untrue. I did make several phone calls to the probation office from Houston while I was in Houston, and I tried to get them to move to Houston, and that was unsuccessful.
Until or unless that happens, it's your obligation to come to them.
I just mentioned like that was untrue.
Are you pleading true to failing to report to the probation office upon release, as this is alleged, voluntarily, and because this is true as it is alleged? Yes.
He was dead.
Yes, I'm asking you, is this true and correct as it is alleged, except for the part that you're talking about? You failed to report as required, and you have absconded or failed to report for 9.5 years. So you're pleading true and correct in that voluntarily and because it is true. Do you understand that a voluntarily and knowingly made plea true to one or more violations of probation, that is all it takes to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation can be revoked and you can be sentenced no less than 180 days up to 2 years.
Yes.
In the state jail. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Mr. Turk, as Mr. Otrumba's attorney, what do you want to add here so the court can make an understood and knowingly made decision on his fate?
Judge, I mean,
looking at how much time, it looks like he has 205 days credit.
Okay.
Already, which is,
Judge, I just want to point out,
over 180 days.
he did make attempts to, albeit maybe not the appropriate level of attempt, but he did make attempts to contact probation over those periods of years to try and get things worked out. He was in Harris County. As you can see, Mr. Trim is not, he's disabled. He did not have transportation nor a support system to get him here to help him do that. And for those period of 10 years, I'm unaware of any sort of issues that he's had criminally. So he's been minding his P's and Q's for that period.
We got a problem though. I mean, there was a victim here and restitution was almost $2,000. Was that ever paid back?
I've made an attempt this week, as you asked last week, sir, to the person that's going to help me has said that he contacted the court and he contacted the DA, and he said both.
He needs to contact the probation office.
And I got the card from the probation officer yesterday, and I messaged him from the kiosk in the jail the information but he said that he's been getting answer machines and all records.
I never get that. I mean, if he's calls up, no, sir. I never get that.
Yes.
If he's calling at 3 a.m, yeah, but not during the business day. They answer the phones. The courts, the district attorney's office, the probation office, I've worked with them for 20 years. I've never had problems during the business day. So that's dunning. We call that dunning. That's stalling and looking for reasons which don't really exist, that aren't realistic. Look, sir, if you can't get this paid back, which is what we have to do to pay a victim back, the only option I have is to sentence you to what would be the 2 years, which is the maximum. But you have to do something that is worthy of entitlement for a punishment that is less than the maximum. And if you do nothing, there's only, why would you receive less punishment if you've done nothing for 9.5 years? See, that's why you can purge this, and I can consider a much lower sentence.
Some yesterday or the day before about the restitution. We told them court doesn't take in money.
No, we don't have to probation.
They're paid probation, or you should.
Hey, but what they're saying is our office talked to them and told them what they needed to do is the right thing. I'm telling you, let's go to probation.
We told them that they could show up today with the money order. If they
Yeah, show up today with a money order. Did anybody do that? Anybody hear from Mr. Trimble? No. Who is it? Was it family or relative or a friend?
Friend.
And why pick new friends? They're kind of letting you stand in the cold, as it were. Do you think they are able to accomplish something for you?
Yes, sir, I do.
All right. Well, I'll give you some time to do that before I make a decision.
Thank you.
Because I just want this paid back. You can get this paid back, and the court's going to be. He's already got 205 days.
I think that's
The minimum's the minimum of this is 180. See, but you pay it back, you get rewarded.
Thank you, sir.
I can wink all day long, but I can't tell you exactly what that is, but you can figure it out. You can go home.
Thank you, sir.
But the people have to be paid out who have been harmed, and that's how you do it when there's a loss of money. Pay it back. But even in this case, it's been almost 10 years they've been out that money. And in all fairness, we don't have a situation like in the federal courts where you have to pay interest on a loss. But if there was, it would be doubled by now.
Yes, sir.
But so the quicker it's done, the quicker you can get rewarded. But I'm going to review this in 3 weeks. Is that okay? All right.
Is it plenty of
Just so he doesn't get forgotten about. Okay.
Judge will urge them to get it done as soon as possible.
Thank you. Reset, and his entry of his plea is the court finds it's knowingly and voluntarily made. I'm going to hold that in abeyance until we hear an update on the restitution. Okay, thank you. Betty Handy will be next. Betty Handy. Hey, Reagan, how are we doing on Cameron Smith and Maximo Urbina?
They're both pleased, Judge.
Okay, thanks. You're Betty Handy, and you were here with Mr. West, Eurotown, and the station. What are we doing?
I think it's about, it was held in advance last time.
I'm sorry, I can't hear.
It's a review. It's a review. I think it was held in advance last time.
Yeah, okay, she pleaded true in January of this year, right? To allegations 1 and 2. And we continue her on probation. You are Betty Handy in cause number 23-41397. And you were placed on back in April of 2023 on 5 years deferred or unadjudicated probation. or injury to a child or a disabled person. And then you pleaded true to failing to report and failing to perform community service hours. We did that back on January 6th of this year, I believe.
Yes.
And here is a review of how we're doing and how are we from probation.
Well, Your Honor,
There's good news.
she last reported to me, this past, November the 4th. I just got her on my caseload back in September. She's got a positive demeanor. She's done.
She tested positive for a
Positive demeanor.
That's good.
It's in office.
We get too many tests positive for drugs.
That's the only
I'd love
positive
it
ones
to
we
be
get.
positive for a good demeanor.
Since I'd say March of this year, she's completed almost 200 hours, 266 hours community service.
She's doing well.
She's
Is
doing
what it sounds. Oh, wonderful. All right.
And she paid $50 yesterday.
I'm sorry.
She paid $50 yesterday.
She made a payment yesterday.
Why did that cause you to sneeze?
I don't know.
He's allergic to money.
He's allergic to
He's
something.
allergic to paying somebody else but him.
Oh, that would make
Not allergic to
sense.
money, but
Yeah,
allergic to people
I
paying money
get
to other
it.
people, yeah.
So here's the important thing, Miss Handy, how do you feel you're doing on this?
I feel I'm doing good.
You're doing the best you can be?
Yes.
Is you're being the best? Well, that's what we want from probationers. And 93% are successful. 93%. 1 out of 14 fail, on our watch. Because probation office does such a fabulous job. This is greater than the national average of about 75%.
Yes.
So if you fail, it's not their fault. They work hard to try to help people get across the finish line, and they do a great job. It's an honor working with them. But you got to do your own heavy lifting. We'll help you, but you've got to take care of it. And it looks like you're doing a good job. Okay, so what are the what is still left to do other than complete 5 years? We reward people for good behavior and doing well by shortening probation in certain situations. You've been on probation going on, it'll be 3 years in April. So what other things does she need to do?
Your Honor, she needs to finish paying up her fines, court costs and things like that.
How much there's no restitution?
No, Your Honor.
Okay. Fines were 500 and is she behind right now?
Yes, Your Honor, she's behind.
Everybody seems to be.
2820 behind in arrears.
2,820.
$2,820 in arrears.
All right. You have children at home?
Yes, sir.
How many?
30.
Are you the sole provider?
Yes, sir.
How do we shut that rising costs down? Can we put her on a type of probation if she's doing well that doesn't add every month so she can catch up in light of her performance and her situation?
Once she completes her community service, probably, or can we do it while she's?
We were going to send over an amendment to the court to hold the rest of community service in advance. She doesn't have to complete that.
Okay, I'll sign that when you do it.
Okay. We just recommend keeping her rocking along and potentially extension in the future, when we know the assessed fees at this point.
Well, what can we do about the curtailing that continue? I guess, what can we do? Is there anything we can do? I mean, we would put them on an inactive, but you don't think she's ready for inactive right now? Okay. And so my active, you have to pay for the costs for the supervisory time and effort that they put in helping you complete this successfully, which is worth the money. But I would like to get to a point where she can take care of the household expenses in lieu of unnecessary costs through the probation office, if we can figure that out. What do we want to do?
So if you're going to do that, General, why don't we just maybe come back in 3 months and see where we're at?
I got a better idea. If we just return back in 3 months, we can figure out.
It's a great idea, Judge. How'd you come up with that?
I'm sorry. Oh, and please get a resetting. Merry Christmas to you. Keep on doing that. Keep doing the good work.
We took ready to go.
It looks like Charles Johnson.
That's Citizen Girl. Yes, sir. He's in custody.
How we doing over there?
Yeah. Yeah, I'm not saying, what change on it.
Come forward, please, sir. And we now call 25 CR 329, the state of Texas versus Charles Darrell Johnson Jr. That's you.
Yes, sir.
Present with Mr. West, your attorney and the state's attorney. You okay there, buddy?
Yeah.
Earlier, you pleaded guilty to this indictment, which alleges the second-degree felony of burglary of a habitation. A pre-sentence report has been prepared. Have the parties had an opportunity to review the report? Are there any corrections or changes to it, state?
None from the state, Your Honor.
None from the defense.
Then it is made a part of the record for all purposes. There is an agreement that's been reached where whatever sentence the court assesses shall not be more than 10 years imprisonment. So we've got no less than 2, nor more than 10 years confinement. He could be placed on deferred or unadjudicated probation for up to 10 years. And he could also be placed on regular probation. I could sentence you to no less than 2, nor more than 10 years in prison, and then suspend that and place you on regular probation. But you've been on probation before, and that was revoked back in 2002. Then it looks like in 2009, you were sentenced to 6 months in the state jail for drug conviction. So that's 2 felonies convictions. And then we have a marijuana possession, which was regular probation. That's a conviction, illegal possession of marijuana, and that was in 98. And then 03, 30 days in jail. These are misdemeanor. Possession of drugs, 30 days of marijuana, another in 2012. There were 2 of those in different. That's odd. Look at that. That's the same exact number. That can't be right. They duplicated that. So it's true. That's got to be an error. Looks like you have 3 prior misdemeanor convictions of marijuana.
Yes, sir.
And then 2 prior state jail felony convictions. And all of these are the same thing. It's controlled substances.
Yes, sir.
All right. Go ahead.
Your Honor.
You may go forward.
Thank you.
If you wish.
Yes, please, Your Honor. We're going to ask the court to put him on probation, and we're going to let the court decide whether regular or straight is the court term probation. Looking back at his criminal history, as you see,
His time, the credit, please. Thank you.
and like the court just mentioned, all of his prior criminal history is all from drug issues. The most recent one looked like the last one was in 2012 was the last conviction. So it's been quite a while since he had any problems with convictions. The biggest thing I want to point out on the PSI, Your Honor, is in the statement of interested parties that the victim of the case, who I don't know if the court remembers, we actually had a trial. This was a plea during the trial. Ms. Part already testified about what was going on. But she did state there in her statement that she does not have an objection to the defendant receiving probation. So if the court was to give probation to this individual, this defendant, the victim is already on board with that, is okay with that. Also, the last sentence there, she said she asked the court to order the defendant not to have any contact with her in any way. If you were placing him on probation, you could make that an order and keep him away from her for up to, and I'm sure the court would do this, 10 years versus if you send him to prison. We all know that he's not going to do a full 10 years, and then the court would have no control over keeping him away from his par at that point. I mean, she can go down and get a protective order or something like that, but it's out of this court's hands. But if we were to give him probation, then the court could order him to stay away from her and make it a condition, and that if he violates it, then he goes to prison for up to 10 years of his regular probation. And if the court defers it, up to 20 years. That would give the court a bigger hammer if the court wanted to do a deferred probation, where you could sentence him to a longer time if he did violate probation. Also, I think they indicated some drug treatment. I think we can get him evaluated to see if drugs are still an issue. Like I said, I know there's a history of drugs, but the last one, like I said, was not, the conviction was in 2012. So I think that probation is probably the best in a case like this. That's all I have to stop. And then the other side.
Let me ask you, before we go forward here.
Yes.
I was thinking about some things, but everybody has reviewed the pre-sentence report.
Yes, sir.
And there aren't any objections here. No, okay.
Yeah. I know that's
All right. All right, go ahead, Steve.
Your Honor, the facts of this case are particularly egregious. He sneaks over to her house, snuck up there on his former girlfriend. He had taken her kids out of the house prior to that in the morning. And he just starts beating her, ends up choking her out several times where she passes out, and she's eventually able to escape. He flees, and then the kids suddenly show up again after he drops them off down the road. Again, she could have very easily died in this situation, Your Honor. I believe it warrants every bit of the 10 years. And even now, the defendant continues in his PSI to contradict the evidence that was presented in the testimony for both her and what her kids, the statements her kids had given as well. He continues to not take responsibility. And in fact, he says, I went ahead and went with it because he said I could get 20 years and I didn't want 20 years. So I still don't have him acknowledging that he did this, and he's still not taking responsibility, Your Honor. And I believe he deserves no less than the 10 years, Your Honor.
Any response?
Your Honor, we can let Mr. Johnson testify about that if you don't mind. I can call him as a witness about that.
Okay. Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
That's right.
Lower your hand. Go ahead, Mr. West.
Mr. Johnson, part of the indication says here that you didn't break into her house, and you still believe that you did not break into the house, correct? Okay. You did go in the house uninvited, correct?
We went into the house.
Hold on. Hold on. Hold on. It's all about what the facts are.
Yes, sir.
I asked everybody, is there any changes or corrections to the pre-sentence report? And there were none. Let me read the second line of paragraph 2 under police version. The second paragraph, on the above date, Charles Johnson snuck up on his girlfriend, Nisha Parr, as she was trying to enter her residence in Beaumont. Johnson then forced his way into the house behind her and began assaulting her. I'm sorry, he forced his way is a violent act. Okay, let's correct the record. You weren't invited in. This says you forced your way in, which means it was without her volition, and then assaulted her.
Your Honor, this is not his statement. He doesn't. What I'm getting at, I was getting to question him, is that he was there. They went in. It wasn't a situation.
He's saying the police are wrong in this report.
Well, the
police said. Well, let's come on.
Well,
let's get straight. Is this? Nobody objected to this. That's what makes me unsettled. I've got to make my decision on the facts. no one objected to this. This is here. He forced his way in.
Your Honor,
Is this wrong or not?
that's the police version. I can't say their version is what they put down as wrong.
Do you debate their version?
We do. His
Okay,
his
all right,
is
but
different.
that's what, well,
It's not, we can't
but
object to
you-
what the police
you need
say.
to- If there's a big difference between what is being said here by the authority that wrote this and you, point it out to me. I mean, I do read this, but sometimes
Also, Your Honor,
these things pass by unless they are emphasized, because this is a big problem right now. He says one thing, the police are saying another. I'm going to be the fact finder. Go forward.
Well, Your Honor,
Go
we
forward.
had the trial, and the defendant or the victim even testified to that. Okay, but his position is that, and I'm trying to get him a question, is that he did go in uninvited, kind of forced way through, but it wasn't a situation where he broke a window or broke a door or went in that type of way.
He was convicted of intentionally and knowingly entering a habitation without the effective consent of the owner with intent to commit assault.
Okay, but Your Honor, sometimes with non-lawyers, they don't understand the difference between breaking into and going out without consent. I think
Facts
that's
are
okay.
the facts.
The facts are the
That's
facts.
all I want. It's facts.
Facts are the facts, but I think when you ask, did you break in, he's going to say no, because most non-attorneys be able to deal with this don't consider just going in without
I've
permission.
done this for
breaking.
40 years. I know what you're saying.
Okay, all right, good. That's what I'm getting at. So I think that explains his version of it, that he didn't break into. I think that's going into it. Now, whether he went in with permission or not, I don't think he went in with permission. I don't think anybody believes that.
But what we're trying to get to are the facts. What's the truth?
Right.
And somebody's version may be different from the facts. Go ahead.
Right. Well, I think the facts are, like I said, the facts are the
I'm a
facts.
fact finder.
He went in without permission and some bad things happened. I think there's no question about that. Okay. The question is in his report, I'm trying to correct his version here, or let him explain to it that it wasn't that he broke into, because I think they asked him, when asked the defendant if he broke into the victim's house, the defendant said no. Okay. So I think that's the issue here is I don't believe he broke into, meaning broke in a door, broke in a window, something like that. But he did enter. If they would ask, did you enter without permission? That'd have been a different question. Okay. So I just want to make sure the court that that's correct. Okay. And it's not an objection to it, because that's exactly what all was said. We're not objecting to any of that, because that's true. But I think the court needs the explanation of that's the difference there.
And it goes, upon entering the residence, this state, he began assaulting her and dragging her through the house by her hair, using his hands to strike her and threw her body about the room. Then used his hand at the front of her throat, grabbed her trachea, then squeezed her throat, cutting off her breathing and causing her to pass out. So does that look like he was invited and welcomed in there, or he snuck in behind her and immediately began to assault her? That's not forcibly entering.
When, Your Honor, there was testimony from the victim that he was in no way invited. In fact, he showed up behind her as she was going in through her garage and ran up on her
Do you agree
and
with that?
went into the house.
Yes.
Okay.
But I'm just saying that the phrase broke into, I think that I don't want.
We're semantics now. Well, I'm talking about he committed the crime of burglary and he was assaulted.
That's why I was.
Let's move on to what the points are. We're bogged down on how he entered the building, but it was for no good purpose.
It was not with permission. It was not for a good purpose, right? But it wasn't a situation where he broke into. I think so. I don't want the court to say that he lied here, because I think his version is that he didn't break into because he doesn't understand what the law says. Okay.
Wait, did he enter her home without her permission?
Absolutely.
Okay, so he trespassed. Okay, that's a crime.
I know. We're not saying that he didn't
To get in, he committed a crime.
We didn't say that he didn't commit a crime.
Let's move forward.
Okay, all right. But like I said, I like to go back to the point where even the victim in this case indicated that probation would be good for him, or she would have no objection to it. And I still think that probation with a restriction to keep him away from her and all the conditions of probation to making sure he lives right would be good. I know he has violated probation in the past. However, in the past, it was a drug-related issue, and that's been quite a while since his last probation. So I think this is the type of case that this would keep him under the court's authority, keep him under the court's eye through the probation department. that this would be helpful for this, both the victim and the defendant in this case.
So, Your Honor, the victim here could have died multiple times. She passed out several times. And by the grace of God, she didn't end up dying and was able to escape. Who knows if she wasn't able to escape, and one of the times when she asked to go to the kitchen, what would have happened in the end. So sometimes we have to protect the victims also. In these types of relationships, we know they tend to want to be lenient on the defendants. However, that's a dangerous situation, and what he did was extremely dangerous and horrible. And with those kids, again, dropping them back off over there, and they have to see the house being completely busted up, knowing their mother has been strangled and beat. I believe, again, every bit of that 10 years is warranted in this case.
What would you like to say, sir? This is your time.
Before we told Middleton that thing that happened.
What happened?
You going
Because he's saying something different than he is.
I went into the house without permission.
And then what?
Yeah, really. No right.
Then what? Oh, she punched you first?
No, sir. I grabbed her phone and she grabbed me and we started wrestling over the phone basically. I had no intent to try to kill her or harm her or do anything.
Well, it says you dragged her through the house, used your hand to squeeze her throat, cut off her breathing, causing her to pass out. When she would regain consciousness, you would continue your assault and squeeze her again. This assault went on for several hours before she was able to escape her house, running to a nearby business where a citizen was able to contact the police for her. She sustained injuries in the form of abrasions, scrapes, cuts, and bruises all over her body. Are you kidding me? You're going to stand by what you just told me, that really nothing, you didn't intend to do anything, this was no big deal, in spite of what this says? You don't understand and appreciate the seriousness of what happened in this person's home where she's supposed to live in peace?
Yes, sir.
Okay. Here's another statement that I don't understand that you made to the probation office. When asked how you're going to do if granted probation, you stated, "I'm going to do good. I'm not really a drug guy." Really? What are you? How many convictions do you have of drugs?
It's 3.
Wrong. Do I know more about you than you do? No, in 98, you were convicted. 1 year adjudicated probation of illegal possession of marijuana. In 2003, 30 days in jail. In 2012, 30 days in jail, marijuana. In 12, 30 days in jail. In 2002, let's talk about the felonies now. 2 years state jail, probated for 5 years for drugs. That's 5. That was revoked and you received 6 months state jail. And then in 2009, 6 months in the state jail. 2 felonies and 1, 2, 3, 4 misdemeanor drug convictions, but you're not a drug guy. You don't have an answer to that.
No,
because it's just nonsensical.
I'm speaking about recently.
Oh, recently, you mean since you've been in jail? You don't use marijuana in
The
jail?
last 12 years, I haven't been.
Let me ask you this. This event, was this caused by drugs?
No, sir.
So this is the way you act when you're sober?
No, sir.
Yes, it is. Okay. Within this. Dead. If not, I'm going to find the defendant has pleaded guilty voluntarily. He is mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilt, your plea of guilty from State's Exhibit 1 admitted to your hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. And I am following this agreement. The agreement is whatever sentence shall not exceed a cap of 10 years imprisonment. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. You can leave.
Ma'am.
You can leave.
You step outside, ma'am.
Step outside. This is what we call justice. Your rich criminal history. You have a rich criminal history. You're held in contempt of court. Get her. She'll be. You can't make an outburst in court.
Get it.
You're going to be given credit for all time you have served, but you can't invade somebody's home and assault them. And with your rich criminal history, we knew better. All right. Okay, anything else to add? No, that is all. You can't make an outburst in this court. You can be held in contempt of court up to 6 months now. Are you related to somebody here?
I'm sorry, sir.
Or that's okay. Are you related to somebody? Who do you know? This man?
Yes.
How do you know him? He's your brother. All right. You were here and you heard what this was all about, right? Did you hear? Okay. It's a very serious thing. And his criminal history was, but here's an issue when he gets out, the family needs to help with this. It's still a drug issue that he's struggling with. And he says he doesn't have a drug problem, but I think a lot of this is based upon what is out there. People don't know what's out there, and what the people are manufacturing cause folks who take it to do odd things, and it's very serious. Some people are dying out there right now for some of this. But I think you're a rational thinker when you're not inebriated with drugs. And I just wish that seems to be your problem. But then you tell me I don't have a drug problem, but you've got all these convictions for drugs. But it's one of these things that the family's going to have to help you. John, I want you to talk to me about what you might be able to figure out what plan you might be able to do to put him into a facility, which this court might consider doing before this term is completed. You know what I mean?
Yeah.
Because he needs that.
Okay.
And the family seems to be supportive of him, but you've got to be firm that his actions can't be tolerated. And it's Christmas time. It's supposed to be where the family gets together and enjoys life, and they're not with you. You're not with them, and but there's a way to avoid that. Okay. Thank you. Let her go. Yes, I am.
Yes, sir.
Okay, Derek Laverne. Laverne is right there. Fine. What are we doing today? What are we doing?
Your Honor, this is an announcement. I think this is just a situation where it's just money. I don't believe there are Mr.
I have this thing in abeyance.
Yes.
Give him it has to be for restitution, I guess, right? Or
there's no restitution, it's just fees.
Yes, sir.
And he's
there's a
paying,
motion to revoke pending that alleges money, all about money. And you had a bunch of, $7,700 in arrearages as of December
Last year.
last year. So where are we on all that?
He made a payment in September of 25 for $100, and he just made a payment in December of $302, but the payments haven't been
In regular.
consistent at all.
So that's been 400 in a year.
Right.
So
And
we're talking
he's-
about, 35.
And his case expired on January 19th of this year, Judge.
We extended it.
Except for the
motion's held.
It's just-
The motion's
holding it.
Okay, the motion's holding it.
Yeah,
Yeah.
and I talked to him about this, and he apparently had lost his job, was not working. He just started a new job.
Where?
I work for an electric company.
Doing what?
I'll go in the attics and drop the wires through the wall.
Full-time job?
Yes, sir.
How much you getting paid an hour?
They pay me by the day. They go anywhere from $100 to $200 a day.
Okay, so, but how often in a month would you say you work? We're trying to get a standardization here.
Yeah.
How much will I bring in a month?
Well, no, how much are they paying you a month? I know you got to pay taxes and other things.
I just started this job about 2-3 weeks ago.
Okay, so you really don't have a
No, I don't have a full
long-term figuring out of a steady, but it's regular?
Yes, every day.
Well, good for you.
And apparently he's made, since he's been working, he's made a payment recently because he's been getting some payment now.
Yeah, my first check just made it through.
Oh, is everything else frozen?
Yes, sir.
Okay, so it's not accruing any more costs. It's just a matter of paying the balance. What's probation saying?
I mean, if it was more regular, I wouldn't, there wouldn't be an issue.
How long have you had this job?
2 weeks.
See,
Right.
maybe
Cross your
it
fingers.
will turn into a regular income.
Yes, sir.
But he sounds like he's positive about it and hopeful that it is.
So we'll go back in a couple months and see if he's been making payments.
That's what I'm gonna do. We'll check on you in a couple of months. Okay, work hard and stay out of trouble.
Right there.
Thank you. John, is it, well, is that it?
I got one more, Amanda. It was Amanda Nolan. I don't think she's gonna be here, Your Honor, but it's one of the status checks, see if she's checking in and doing what she's supposed to do, but I don't think she has everything that she's supposed to do.
Who is it?
Amanda Nolan?
Okay. Amanda Michelle Nolan, cause number 1932306 is called. Amanda Nolan. There is no answer in the courtroom. I asked the bailiff to call into the hall, please, for Amanda Nolan. And the court will note a first amended motion to revoke probation has been filed in this case. She's on a regular probation, failing to report, I guess, and then first amended, failing to report. Is she in abscondence now?
No, just this month, she hasn't really returned any calls or reported in. Yeah, Brady wait twice, she didn't show up.
Okay.
There's no response.
There's no response. Defendant has failed to appear. A warrant shall be issued for her arrest. She's on regular probation. What I'm going to do is, there is no bond on this. When she gets arrested, we'll know and we'll bring her forth. But she's on regular probation, so no bond is allowed under these circumstances. All right, John. Thank you.
It's all. You have a very Merry Christmas, Your Honor.
All right, Santa. Remember our address?
Close that one. Y'all.
Okay, I've got Reagan on Ezekiel Johnson.
Judge, she's in custody.
Okay, Ezekiel Johnson, please.
Here, Judge, you accidentally gave me the file earlier.
Did I?
You did.
What does that say?
That.
I'm trying to move my cases.
What? Need to call your desk.
By Okay, I hadn't seen these. I've got a gaggle of letters on his behalf that's been sent. I just opened the file. There it is. I didn't know these were here. Stats are all. You're Ezekiel Johnson? Okay. Is Catherine Edmond here? Okay, I have a letter on your behalf, but it's not signed. You just, that's okay, but you did send a letter.
That's my job. We didn't know they had to be individual.
Oh, well, generally letters are signed, otherwise people can just print them off and, you know, use other people's names and all. But you did want this,
Yeah,
you approved this.
yeah, I'm not Catherine Edmond.
It says you. This is Catherine Edmond RN.
Yeah, that's my daughter. She's not here today. I wrote a letter too. I'm saying.
Oh, okay.
Catherine's my daughter.
Okay, but Catherine didn't sign. Are you Hannah? Are you Hannah? Okay, I've got Hannah Byers as well, and that as well.
Some of them are individual. I didn't know they.
Okay, how'd y'all send them? Just fax them or something? Okay, but everybody, let me look at this other one. Then I've got something from Robin Byers. Okay, and then Tabitha Armstrong. Okay. Lee Byers the second. Lindsay Byers, and you're not even a signature line here, but that was meant to be sent to me.
Oh.
Okay, and then from Parker Johnson and Anisha Belton
It's all bad.
and Rupert Johnson.
That's pretty much the right bottom.
Okay, all of those are, I just want to make sure because they're not signed, but they're all valid.
Yes, sir.
Okay.
All
I
right.
hadn't looked at these. I don't have these.
Ask the number. So.
I wasn't aware, Judge, they were sent directly to you. They did not come through my office.
Let me go, there's something else I'll get back to you on this one.
So we haven't agreed upon the resolution, it's not.
But it's a motion to revoke unadjudicated probation, so I don't have to do that. It's gonna be whatever I decide.
Sure, Judge. I have 3 others that we could do first.
What did you?
2 years TDC, Your Honor. He's got new cases out of Nacogdoches
Is there any
County.
loss of is there restitution or anything?
Usually they punish you, but you
You can have a pre-sentence report on this for the. They also found the weapon at public place when he was put for that.
Yeah, I think I've done.
Dan, I must say, the tie and handkerchief.
In motion practice, when there is an attorney on the other side, I believe it is inappropriate to make ex parte motions. I think the proper procedure, in my mind, should have been to reach out to our office first to see if we would have stipulated, and quite frankly, we would have as a courtesy. And then if in the absence of receiving the courtesy, then filing the motion and perhaps requesting a hearing before Your Honor. Certainly, Ms. Bauer being out of town was an appropriate excuse for an adjournment. We've I think adjourned cases from her office before by stipulation, and I was surprised that it was done on an ex parte basis, and to a degree, even more surprised that the court considered it when the court was aware that there was counsel on the other side. If my understanding of the rules is incorrect, I will happily stand corrected.
No, I think your court rule is correct. There was an escrow in there. But Ms. Bauer, how do you address that? He is taken aback by your ex parte request to adjourn this and my willingness to grant it. I would not have granted it had there not been an escrow order in there, but what's your response?
Thank you, Your Honor. The adjournment request was less important than the escrow order. We were asking for that escrow order because my client has been unable to pay her rent, because the whole basis for this case originates out of plaintiff's unwillingness to accept anything less than $175 per month in late fees. In order to give my client a place to pay her rent so that she didn't lose it, we needed an escrow order so that it could be secured and so she could demonstrate her good faith. I have been in communication with plaintiff's firm about a previous case at this park, the Kloppenstein case, with no response in an attempt to, they were refusing his redemption. I sent letters to Mr. Levine's office. And so in light of the fact that I needed an appearance in order to get the escrow order, but was going to be out of town, I had to also ask for the adjournment. Well, that said, this issue has been a repeated issue clogging your docket and being inappropriately addressed by this park, I think. And so we needed to get this in front of you so that we can get this resolved. Now, Mr. Landman has said today, for purposes of this hearing, we're going to charge $120, but that doesn't stop the fact that they are continuing to charge the tenants.
All right, well, you're getting an argument. The proper procedure would have been asked to adjourn it. You asked for the emergency. Certainly, they wouldn't object to an escrow order, I would think, but both you and me didn't clearly strictly follow the rule here. For that, I apologize, Mr. Landsman. I'm sure you would have agreed to the adjournment. At any rate,
Your Honor, if I may,
at
one point in time, I was known in Ms. Bauer's office as quote unquote the nice one from Swistak and Levine. That was due in no small part to the fact that my cousin used to work as a legal assistant in that office. So certainly I would like to think that I have dealt at all times, although adversarially, with individuals in that office respectfully.
all right, well, let's try to parse this out. The defendant's contention, both in the previous case and this case, is that the plaintiff wouldn't accept payment without their, and nobody allows $175 a month late fee, probably anywhere. And I think this is lot rent. There's a bunch of extra stuff in here, which isn't in the lease, which are little things. The $850 times 3, the sewer is certainly this administrative fee of $5 a month, mobile home tax, line fee. I don't know if those things are in the lease or not, but those may also be issues, but it's in the billing. It shows mobile home tax, administrative fee, meter fee, lot rent, so they were aware of it. But so let's talk about what we're at right now, Ms. Bauer and Ms. Speech. Lot rent $440 per month, October, November, December. Are we in agreement with that?
Yes.
All right. Late fees, 3 months at $40 per month. Now, defendant may claim she's not late because she's tried to pay October or at least November and December, and the plaintiff wouldn't accept it. What's your response to the late fees, Ms. Bauer?
Ms. Speech voluntarily or sua sponte attempted to pay a $50 late fee on October 17th on top of the balance that they claimed she owed, and that payment too was rejected as below minimum. So we object to anything in excess of $50 in late fees. I do also want to put in here, we object to court costs because this case, because she attempted to pay the entire balance through October plus a $50 late fee of her own that was prior to receiving advice from counsel on October 17th. And then subsequent to that, she attempted to pay all of the assessed charges, $440 in lot rent, the meter fee, admin fee, the tax, line maintenance fee. She attempted to pay all of that, plus the prior month, plus the $50 late fee on November 4th, which would not under the lease trigger any late fee provisions. So the only late fee that the defendant would consent to in order to seek resolution perhaps would be a late fee for October.
I can't tell from what I'm looking at how much I have in escrow. Maybe I can look in the electronic file. Can you tell me how many escrow payments you've made, Ms. Speech?
2.
So I have 886.
Judge,
I paid
you have
1,068 at first, and then I just paid December's before it was late, which was $514. So you have like 1,500 and something in escrow.
Judge,
3 months.
1,068 was paid on November 21st, within a day or two of when the escrow order was entered, and then $512 on December 5th, according to the receipts I have, for a total of $1,580.
All right. Where does that bring us?
That brings me.
All right, we'll see.
Looks
Mr.
like there's a
Lansman?
difference of $79.76, Your Honor.
And that would be the $280, the $240 late fees that we dispute. And of course, Ms. Speech would have no notice of this sort of random imposition or decision on the number for the late fee, so she would have no way to account for that. But again, she wasn't late. As soon as the escrow, she attempted to pay on November 4th. It was rejected by their lease pay system. So we asked for the escrow.
Just a minute. Mr.
Yes, yes.
Senzo? Would you unmute your mic?
Hi, Your
I'm
Honor.
gonna blank your camera out. Viewers have contacted the court regarding your behavior on the screen. You're very animated about agreeing or disagreeing with what's going on. They felt you were very disrespectful to the court in the last hearing and were shocked that I didn't do anything about it. I wasn't paying attention, but you're doing that now. You're very animated with your approval or disapproval of what is being said. So I'm going to shut off your camera, but you'll be able to see us.
Understood.
And Your Honor, I will also jump in at this point and indicate to whichever viewer or viewers felt that shaking one's head is disrespectful, I am happy to take it up with those viewers directly, and they may feel free to contact my office, because I am completely and utterly opposed to their position.
Well, Judge, I would like to take a point to say that I have actually had repeated concerns about the respect that this park has treated to my clients during these hearings. And for example, when Ms. DeCenzo's colleague shared his screen with my client's personal information on the YouTube feed without your consent and over my objection, it is not just the viewers that have been concerned. But I'm not here to make ad hominem attacks. I'm just here to get this resolved.
Yes. There we go. All right. She can hear us, but she can make all the gestures she wants and nobody can see it. All right. So we're getting close to where we need to be. So, Mr. Landsman, what's your response?
Your Honor, the tenant, firstly, I disagree with the court that quote unquote, no judge would allow $175 in late fees. I could list several judges across this state that have allowed that or more. If this court chooses to have its own cap, there are other courts that have done so.
The law on late fees isn't even clear. Some judges allow no late fees.
That's true. And some others have caps based on whatever their reasoning
Yeah,
is,
so
and
it's
others
kind of the
allow
Wild
late
West,
fees
but I
in
didn't know
full.
anybody was allowing one that big. But maybe so. You practice all over. I'm just here in Little Centerville, but yeah, the law on late fees, in fact, if you read it carefully, it doesn't even seem to allow it at all. But I've always allowed it and I've let the number go up, but at any rate, fair enough.
And
But
what I will say is that this tenant agreed to late fees of $175 in the lease. The lease is a contract. The words of a contract are to be given their clear meaning pursuant to Rory versus Continental Insurance, which is the landmark Michigan Supreme Court case in that area. As far as my client's rejection of the payment that was not a payment in full, if it had accepted that payment pursuant to Park Forest of Blackman versus Smith, Court of Appeals decision from, I believe, 1983, my client would arguably have been prevented from filing this case. So therefore, it was justified, in my opinion, based on the prevailing case law, as I understand it, from it was entitled to reject the lesser payment. With that in mind, obviously, this court is entitled to make whatever ruling it
let me
wishes
stop
in
you
terms
before
of
you
what
go
may be
forward.
owed.
This isn't a termination of tenancy case. It's a non-payment of rent case.
That's right.
And Park Forest doesn't apply to non-payment of rent cases. It applies to termination of tenancy cases. So if you file a termination of tenancy, you're right, you're not supposed to accept any payment after that. If it's filed as a demand for non-payment of rent, the defendant is entitled to tender rent and the plaintiff's supposed to accept it. But
I appreciate, Your Honor, this court's interpretation. Again, we practice all over the state and other judges have taken a different position. So therefore, we advise our
they've
clients to
taken
err
a
on the side of
position that
caution.
Park Forest applies to non-payment of rent cases?
There have been rulings to that effect. We have
I've
not,
never
we don't like them, but there have been rulings to that effect.
All right, well, so what does that do for a tenant? Some judge in Sanilac ruled you can't make a payment on a non-payment of rent case. So here in Centerville, the landlord decides he's not going to accept any rent. I've never even seen that before, and I just picked Sanilac out of the air. I'm not accusing the judge that may be there, but at any rate, we need to get to where we need to get to. So, all right, enough of me venting. Go ahead, I cut you off.
Oh, no, I was just going to say that obviously we have to keep track as best we can of which judges are interpreting things which ways. And certainly I will note, and my office will note, that in your opinion, Park Forest doesn't apply in non-payment of rent cases, and we appreciate that input, and we will work accordingly with that.
I think I may have mentioned this before. We had a session a number of years ago when I first came to the bench on landlord tenant law. And Craig Alston was the judge. He was the acknowledged landlord tenant guru in the state of Michigan for district judges. There were more than 200 judges there, maybe more than 150 district judges. And he put these scenarios on the screen and we would discuss these scenarios and you get 8 different answers to the same question. And I remember thinking, isn't the law supposed to be more clear than this? And so I made a decision at that point, at least I'll do it the same way every time so the lawyers will know what to expect. As you know, right now, there's a big dispute as to whether you can do a non-payment of rent case in a lot only mobile home case. Some judges have ruled that you cannot do it, and other judges like me allow it because it can benefit the defendant. So all I could say is I try to do it the same way every time so lawyers know what to expect, even though there may be some differences in how other courts do it. I think I'd mentioned a judge wrote a very learned opinion on why she does not allow it in her county. And I've read several briefs from law firms, I think including yours, on why it should be allowed, but we need more guidance. So we're not terribly far apart.
Judge, may I
yes?
address some of the points my
Well, I
colleague?
didn't let him finish what he was saying. Yeah, I keep cutting him off, so I'll let him finish and then I'll let you respond.
Thank you.
And I appreciate the court's consistency, and I think certainly when I've appeared before you, Your Honor, on these types of cases, you have been consistent. So as such, when we were scheduled for this morning, thus the reduction in the late fees to $40 a month in conformance with this court's policy. I'll yield the floor to Ms. Bauer.
All right, Ms. Bauer.
Thank you, Judge. To address the Park Forest issue, it is inconsequential in this matter. Plaintiff's complaint is dated October 20th. However, Ms. Speech attempted to tender the entire balance due plus the late fees, a total of $563 on October 17th, 3 days prior to the filing of this complaint. So Park Forest, even under Mr. Landman's interpretation, wouldn't apply until a case had started, but she had attempted to make her payments prior to this case starting. So regardless of the interpretation, that issue doesn't hold water. She attempted to pay them everything she owed. They still rejected it because she did not attempt to pay them $175 late fee. So let me turn to that issue.
All right, well, let me stop you right there. Mr. Landsman argues she signed a contract that said she agreed to pay $175 a month.
That's exactly
and
what I was
me
going
or
to.
you or somebody else said, well, hey, now granted, they should have accepted whatever she tendered, but the lease says that the late fee is $175 a month.
Judge, that was my next sentence. I said, so on that, to that point, a contract clause for late fees is a liquidated damages clause. It is supposed to be a reasonable estimate of the actual damages that are otherwise hard to calculate. That the breaching party occurs as a result of the non-breaching party occurs as a result of the breach, right? That's liquidated damages sort of 101. However, a liquidated damages clause is unenforceable if that clause is a penalty. If it is not intended to recover or account for actual and estimable damages actually incurred. So we have two issues here. As I'll say, the defense's position is that, sure, that clause for $175 is in the contract, but it is a penalty and therefore is an invalid liquidated damages clause, and the court should not enforce it. I can provide a couple of citations, although Ramada Development Company versus United States Fidelity, and
well, I'm not proposing to enforce it. But so they, even under your client's position that they should have accepted her payment, it was not payment in full. If she unilaterally decides I don't have to pay the late fee, I hadn't made a ruling on the subject, the plaintiff still would have had a right to file this action, which they did, because there would have been at least some arrearage at that point, which so I would be inclined to allow the court costs.
The judge, by that argument, my client has to pay in order to defend herself.
Mr. Senzo has got her hand up. Mr. Senzo, you had a question?
Hi, Your Honor, yes. I just want to apologize. I am a very animated person. And I promise you it's not a sign of disrespect, more of a just upset that we're even here. We don't want to be here, and we respect your time, and we did not want to come to court today. So in compliance with the last two rulings that you have given in this courtroom, we actually did change our late late fees, whatever the term you want to call them, in efforts of trying to do right by you and your judgment. On the 20th of November, we actually sent a notice to our tenants letting them know that we were going to be actually obliging with your $40 late fee recommendations. And we sent a notice to Donna on the 20th of November, literally stating that we want to remain in compliance with your recommendations and that we were dropping the late fees to $40 for all tenants. And she still chose not to pay in December.
All right, thank you.
I'll
all right.
state that at that point, the escrow order was already in place. And I do believe that had we not filed this motion in order request for ex parte order, this change would not have happened. We are glad to hear this change. But I don't believe it would have happened had we not had to file, or had we not filed.
May I speak?
Yeah, I let her speak.
On November 4th,
Now you have to speak up.
on November 4th, I did try to make my payment for November and October's with $50 late fee instead of a $40 late fee, and they locked me out. For 6
That is
weeks, I
reflected
tried to
in my
make my
notes.
payment.
Yeah, that's
locked out.
your attorney's already represented that.
So I just wanted to respond because she's saying November 20th. Well, how come you didn't let me pay it on November 4th? And after that, it was done. The escrow order was in.
All right, we are very far apart.
So I let my lawyer do the rest and they kept
Yes,
harassing
fair
me.
enough.
So
All right, so plaintiff's claim right now is for $1,659.76. And that's through December with a $40 late fee and the other related fees. Defendant has paid to this point into escrow $1,580. Which is, as Mr. Landsman said, $79.76 apart. And as Ms. DeCenzo says, she didn't want to be here. I think it's unanimous. None of us wanted to be here, but here we are fighting about $79.76. But as Ms. Bauer said, these challenges have led the park to changing some policies and procedures, and they're new owners and they're learning our procedures. So maybe there's some benefit from this. The other issue is the filing fee of $170.05 that defendant objects to. And I didn't make a ruling, but I indicated my inclination is to allow the court costs. So that would be $79.76 minus $170.05. $249.81 would be the total through December. All right, Ms. Bauer, do you wish to again make your argument as to why there should not be any court costs?
I do. I'm looking for the citation right now. There is a portion of the Summary Proceedings Act that suggests that the court should take into account whether or not to award the fees based on whether there is any mitigation in the amount demanded. I believe it is 600.5741. In determining the amount, yeah, it is that section. And had
600.5701.
5741. In determining the amount due under a tenancy, the jury or judge shall deduct any portion of the rent which the jury judge finds to be excused by the breach. The statement in the judgment shall be the judgment. All right, I'm sorry, Judge, that is not the right citation. This being a first hearing, I didn't realize we were going to be litigating it this far today.
Yeah, there is that. This is just the first hearing. I was hopeful we could get to the finish line today.
If the plaintiff fails to prosecute his complaint, or if upon trial or motion the plaintiff is found not entitled to possession of the premises, judgment shall be rendered for the defendant for his costs, which shall be taxed and collected in the same manner as other civil judgments. So MCL 600.57.47. The only thing litigated here, the only damages the plaintiff was seeking is those $175. Had we not filed this motion, had we not asked the court for an injunctive order preventing the park from assessing these fees in the future, this change wouldn't have happened. So to award the plaintiff its costs is to reward them for filing these actions and to penalize Miss Speech for defending her case. And we have not asked for my costs and fees in this case. Although we could.
Your Honor, the motion for the ex parte escrow order requesting injunctive relief, I think, was horribly overbroad. An escrow order can be entered without an injunction. This court never granted the injunctive relief requested by Ms. Bauer, and it would have been wholly inappropriate to do so without holding a hearing with notice and an opportunity for response from all parties. She could have requested perhaps a temporary restraining order with later an injunctive hearing. She did not attach an affidavit or any other item that would have persuaded this court that her client was suffering irreparable harm. So I think to argue at this time that this court granted injunctive relief, quite frankly, probably the appropriate remedy would have been filing a separate lawsuit in perhaps circuit court and asking for equitable relief. But I think to argue today that somehow this court granted her an injunction and therefore she's the prevailing party, I think is wholly misplaced and flat out wrong.
Judge, that's not what I'm arguing.
I thought all I granted was the escrow.
That's correct. That is all you granted. And I'm not arguing that we prevailed on that. Also, plaintiff didn't file a response to my motion, which they were.
It was an ex parte motion, Your Honor. It wasn't scheduled for hearing.
No, that doesn't, the motion rules for filing a response, the timings still apply. The point is, we're not that we prevailed on that request. The point is that we prevailed on getting the late fees mitigated, potentially. You haven't made a ruling yet.
Well, you did just now. I didn't even make a ruling. They just capitulated and agreed to move it to $40. I didn't make a court order or a court ruling. They just agreed to it. My opinion is they're entitled to their costs. We're going to set a second hearing and you guys can think about it in the meantime, which would mean through December, the defendant would owe $1,659.76, offset by $1,580 that's presently in escrow, leaving a shortfall of $79.76.
Judge, you're intending to award them late fees for November and December, despite my clients paying within days of the escrow order and paying on the escrow order on December 5th?
Because it's not late until after the 5th. And I was not late for November.
Yeah, that's a legitimate point. I don't want to fight about this anymore. I'm gonna kick this can down the road. I resent spending an hour and a half to fight about $80, but we'll have to try to be accurate, even it is a small amount. You're trying to make your point.
Attorney
And,
Landon could have called me also. This is the first I'm hearing of the concession.
The first I'm hearing of it as well.
Oh my goodness.
all right. December 29th is quite full, but in for a penny, in for a pound.
I'm going to start using that at our case review decisions, Judge.
Yes, well. Yeesh. That's the first day back after the holiday and it's already crammed full of stuff. We're gonna continue this. And again, every time we continue it, it's an additional cost to the plaintiff. Defendant doesn't pay cost for her services. Ms. Bauer argued that perhaps there should be an assessment of their costs. But maybe the parties can just agree, can agree to settle on a figure, in which case neither party would need to appear. But I'm going to continue this to
Judge,
12/29/25 at 2:45. Yes?
Although we are a nonprofit law firm, we do still incur costs, and we are authorized by statute and by our regulations to request costs and fees. We just simply don't do that very often because it tends to harm our clients more than help.
Yes.
Your Honor,
I'm
they're
not
only
ins-
entitled
I'm
to
not
costs.
insinuating you didn't incur any costs, but your client didn't. Now, she's well represented here, and you're fortunate to have competent representation.
Yeah, I'm very lucky. And I'm very appreciative.
As I indicated, they're new to this park, they're new to this business. They're well represented also. Jared Levine practices landlord tenant law all over the state. That law firm does. Mr. Landsman's been around and he's done a good job for his clients in the past. And sometimes we need to fight it out a little bit to get to a place where everybody knows where to go moving forward. So I think we're getting there, but we're fighting about not very much money. I would like to resolve this in December because I don't want to do another escrow payment in January.
Thank you.
I'd like you to just pay your rent to your landlord. But we're not very far apart. Ms. Bauer contends, perhaps with merit, there should not be a late fee for November or December because she attempted to tender the rent and the plaintiff wouldn't accept it. So in essence, we're fighting about $80. Well, we're actually fighting about 24 cents.
$140.
If I took the two late fees out, the arrearage would be a 4-cent credit. I would allow the attorney fees and the costs. So if I grant $80, you'd have a 4-cent credit toward January's rent. And I would allow the court costs of $170.05. So that's where we are. Not 4-cent, a 24-cent credit. All right. I don't know if you guys are in a position where you wish to speak to each other at some point further, but I'd encourage that. We'll come up with some sort of a ruling on December 29th. All right. Thank you all. Mr. Senzo, thank you for your input as well.
Thank you, Your Honor, and I will wish the happiest of holidays to the court and its staff, to sister counsel, and to her client.
All right, thank you all.
Thank you, Judge. Ms. Speech will be in touch.
All right. Miss Brewster is still in the waiting room, Meg.
Alrighty.
Miss Finch, you're good to go.
Thank you, Your Honor.
Well, she was in the waiting room. Elaine, did Miss Brewster get tired of waiting?
Sorry, I got busy.
Did she leave?
She did, but she left her phone number for Meg.
All right, I'll close the live feed. I just learned that I have a PPO hearing that I didn't know I had at 1:15, so we will be not live streaming that. I was gonna go to a judge's retirement party in Coldwater. Sure, I'll make that or not, but we'll be